now, everyone. Okay, we've started, so people will be joining us now. And I'll start talking to everybody soon. And that's my colleague. Salut, Cécile. I think everyone's going to join. So just so that you know, there's about 150 participants that have joined, that have registered. Okay, and I can see the participant list going up. It will go up a little bit more. They can all see us, but welcome everybody. I'm just going to wait for a little bit longer for the participants to go a little bit higher, but we have all our guest speakers here. I think Gisela, Erica looks like she's having a problem connecting. It's going forever. Look a bit funny that we're all here. It looks like.
Sí, Edwin, a lo mejor usted podría indicarnos si su compañera está teniendo algún problema para unirse al seminario web.
Estoy escribiéndome con ella y se está conectando.
Perfecto, muchas gracias.
Gracias. Gracias por tu español tan bonito.
De nada, un placer.
Oh, good, there's Laura as well.
Yes.
Oh, good, Erica, it's working for Erica now. I can see that she's on. Hi, Laura, as well.
Hi, good morning.
I don't know if I'm allowed to start a little bit before 11:30. Maybe I'll wait 2 more minutes and then I'll start 2 minutes before. But anyway, hi Laura. Hope you're well.
I will not be putting the camera for the moment, and I may be.
Yeah, no problem. No problems.
Thank
no
you.
problems. Look, everybody's on time.
Yeah, would you like me to connect through the webinar link rather than the panelist link?
No,
okay,
it's better that you connect through this one because otherwise you can't communicate with us.
But then I can reconnect at the when we get to the second panel.
No, it's all good.
Erika está excusándose, sí tiene problemas, estaba conectada y pues decía que estaba hablándonos, pero no la logramos escuchar. Va a tratar de salir y volver a ingresar.
Perfecto, perfecto. And Mia, he's saying that Erika is having problems with her microphone and she's gonna try rejoining again.
Yeah, I can see because we can't see her, but you can see that it's playing. Okay, but I think but the only person, Gisela, if you want to send an email to Ina, because she's speaking in this first session and I'm not sure where she is.
Okay.
No, I think they're going to know. I will start 2 minutes before. Okay, now it is 2 minutes before. Okay, so what I'd like to do is thank you, everybody. My name is Mia Dumbach. I'm the Executive Director for Child Identity Protection. It's a real honor for me to have you all here today. And what I'd like to do before getting into the content of the webinar is just do a bit of housekeeping. which I think is important for every webinar that we have. Firstly, as I moderate this session, I will be introducing all the speakers, of course, but I will not be going through their bios for two reasons. One is because most of them you know very well if you've been working in intercountry adoption. They are the cream of intercountry adoption. But secondly, their bios are on our website in French, English, and Spanish. Secondly, this webinar will be in English. We will, depending on demand, we are open to translating into French and Spanish, depending on our resources. It is being recorded as we speak, and that we will put on our website. I'd also like to take this opportunity to thank two colleagues that have particularly been working in the background to make sure that this webinar works and is operational so that everyone can participate, and that's Gisela Gomez and Sienna Dimitri. So thank you to them, because they're the ones that really made sure that technically this works. Also, we've made a decision that in order to make the most of the internationally recognized experts that we have present today, we will dedicate the entire webinar time to their presentations. So if you do have any questions, feel free to send them to us at info@child/identity.org, and we will respond to all relevant questions following the webinar. So that brings us to the end of the housekeeping rules and brings us now to the content part. So in terms of child identity protection, we are a new organisation that has been working on promoting identity rights in many, many fields, of which intercountry adoption is one, an important one. And for us as an organisation, what we'd like to do with our webinars is to make sure that states comply with their responsibilities to really preserve those essential elements of a child's identity. So their name, their nationality, and for us in particular, the family relations. And that's a wide view based on what the Committee on the Rights of the Child has defined as family. So all those potential family relations. Secondly, it's very important for us in terms of the restoration of the child's identity. Whenever there are elements that are missing, those fundamental elements that I mentioned earlier, they're missing or they're falsified. For us, the Convention on the Rights of the Child, Article 8.2 specifically states that states have a responsibility to speedily re-establish these identities. And so that is our mission, that is our vision, that every child has a full and transparent identity. So without further ado, let me introduce you to our first speaker, Professor Benyam Dawit Mesma, Committee on the Rights of the Child member and Deputy Dean of the Faculty of Law at the University of Western Cape. He will speak to us today about the work of the committee and the scope of its work. Thank you, Benyam.
Thank you very much, Mia. It's a pleasure to be here and reconnect once again with a topic that I hold very close to my heart. I've started my academic work on intercountry adoption many years ago, and of course, even within the UN Committee on the Rights of the Child, I still have a bit of interest in terms of the engagement that we have with states when they come for the review. I have limited time, so it's important that I cut to the chase, as they say, as soon as possible. But a couple of disclaimers. One is, even though I'm a member of the UN Committee on the Rights of the Child, I'm not speaking on behalf of the committee, even though I will draw quite a bit from the jurisprudence that we have as the UN Committee on the Rights of the Child. The second is, even though Article 7, Article 8, Article 20, 21 of the Convention on the Rights of the Child are probably the most important ones for the conversation of this topic that we're having today, inevitably, the promotion of children's best interests, including in relation to the right to identity, requires quite a whole range of other provisions to come into play. So a systems approach, obviously, to deal with the violations when they happen, but even more importantly, for the purpose of prevention is absolutely critical. Now, one other disclaimer that I need to mention is, even though the Committee on the Rights of the Child actually monitors the implementation of the Convention on the Rights of the Child, we don't do that in a vacuum. There are a whole range of other international, regional instruments that actually have a bearing, not just only for the topic that we're discussing today, but also a whole range of other topics. So to kick off with that as a starting point, of course, the Convention and the optional protocol on the sale of children, child prostitution, and child pornography are important, but so is the Hague Convention of 29 May 1993 on protection of children in cooperation in respect of intercountry adoption. I'm not going to go into much detail there because there are other more qualified colleagues that are here for that conversation. But suffice for me to say that the link between the convention and the Hague Convention actually goes many years ago, many years back, because of the relationship that exists, because of the overlapping nature of the drafting of those two instruments, but also because of the fact that Article 21 relies quite a bit on some of the provisions that are actually existing within the Hague Convention, and to a certain extent the other way around as well. So it should come as no surprise that the CRC committee has consistently and systematically recommended to states parties to the convention to also ratify the Hague Convention. In fact, it starts from since early 1994, before the coming into force of the Hague Convention itself. So if you in fact track those recommendations that have been coming from the UN Committee on the Rights of the Child, look at the detail in terms of the language that has, it's partly shifted with time, emphasizing the increasing importance of the ratification of the Hague Convention, not just only the general intercountry adoption issue, but also with a view to deal with illicit activities, with a view to facilitate cooperation, which are all equally important for the purpose of the child's right to identity. Now, beyond ratification, we've also, as the UN Committee, have asked a number of states, for example, at that stage, France, Kenya, Guatemala, to ensure the application of the safeguards of the Hague Convention, including in the instances where children are being adopted to or from non-Hague countries. So our jurisprudence is not just only limited to asking states to ratify, but also asking them to make sure that the application of the provisions, including in the instances where children are being adopted to or from non-Hague countries. And again, this is absolutely critical with a view to promote children's best interests. Now, in terms of the ratifications, there is a very long list of countries. You can look at Benin, Kazakhstan, Chad, Japan, Republic of Korea, Tonga, Lao People's Democratic Republic, Angola, and so forth, where we've actually given those recommendations. And fortunately, quite a number of them haven't disappointed. Quite a few of them have actually come forward. We don't necessarily take credit as the sole body that is actually pushing for ratification, but it's a combination of other factors as well. Now, as the Committee on the Rights of the Child, the 4 cardinal principles also play a very important role. And prime among this is obviously the child's best interest. And we know for a fact that when it comes to adoption, what is provided in Article 21 says state parties that recognize and or permit the system of adoption shall ensure that the best interest of the child shall be the paramount consideration. So when we're talking about Article 7 and 8, in terms of the child's right to identity, when it comes to adoption, one can even make an argument that there is a heightened obligation that states are actually expected to stick to when they're dealing with adoptions, intercountry adoptions in this case particularly, that would have implications for the child's right to identity. If you go through the jurisprudence, we have made recommendations, for instance, in terms of the need to ensure timely decisions and transparency in the assessment and review of the adoption process, because that is part and parcel of an integral part of upholding children's best interests. The relaxation of differentiation of adoption processes based on the close relationship of the adoptee and the prospective adoptive parents has been seen by the committee that it could compromise the child's best interests. In this regard, for instance, in the context of Japan, we requested that, and I quote, all adoptions, including those by a lineal relative, end of quote, of the child, should be subjected to a judicial authorization with a view to promote children's best interest as the paramount consideration in adoptions. So again, these are some of these irregular activities, illicit activities often have negative implications on the child's right to identity. And I'll come to the illicit activities in a moment. Of course, the consent of biological parents, caregivers, I mean, it's a choiceless choice. I have not just only had the opportunity to look at this topic from the academic point of view, but I've also been engaged at the practical level as well. I have been on the ground, for instance, in Ethiopia many years ago, when my own country was the #1 sending country from the African continent for about 5,000 children per year. Those are the ones that are going through the formal channel where, you know, parents were going and crying in front of the Ministry of Children's Affairs, Women, Children and Youth, saying about the fact that the consent that they gave was not valid. They were promised a number of things, that the children would actually go overseas. In the majority of instances, these parents, caregivers, are parents who do not necessarily have the means, capacity, and even know-how. It was heartbreaking. I mean, then, but even now, it's mind-boggling that an African mother wouldn't understand the whole notion that you put your thumb mark on a specific piece of paper, and with it goes all your rights and responsibilities as far as that child is concerned. And of course, biological parents and caregivers and the importance of consent is an issue that we have spent quite a bit of time as the Committee on the Rights of the Child in engaging with states. There is obviously a link between the need to facilitate domestic adoption, which often manages to maintain and ensure the child's right to identity better, not always, but in the majority of instances, better than in the context of intercountry adoption. In fact, in some circumstances, the child's right to identity is often violated when the subsidiarity principle is not adhered to. And there were occasions where a number of countries came to the Committee on the Rights of the Child, and they were quite often focused on facilitating intercountry adoption, but there wasn't really any concrete measures that were being put in place to facilitate domestic adoptions. And we have engaged with many of those countries, whether it's Cape Verde, whether it's my own country or Kenya, and a number of other contexts where we've actually engaged with them to make sure that that doesn't happen. Now, of course, when we talk about the child's right to identity, again, it's not just only Article 7 and 8 and 21. The child's right to be heard plays an absolutely critical role to ensure that the child's right to identity is also upheld, in this particular case, in the context of adoption as well. If you look at our general comment as the CRC Committee on Children's Right to be Heard, it eloquently captures actually the role of the right to be heard in adoptions. It leaves no doubt about the vital role of having a child heard when a child is to be placed for adoption, as well as when a child, it says a child finally will be adopted. So it's not just a once-off, but actually a process in which children, particularly those who can be heard, can share their views. Now, in relation to children's identity right, and I will shortly wrap up on this point, particularly for older children, maintaining original names and surnames might be very important. To illustrate, in Niger, government has reported that with a view to preserving the child's identity, their law provides that in case of simple adoption, the adoptee keeps his or her original name, to which the name of the adopter may be added, if the child so desires. The government of Australia had been asked to ensure full respect for the rights to identity, including the name of the adopted Aboriginal and Torres Strait Islander children, and so forth, so forth. This may be in the context of domestic adoption, but some of them are also relevant in the context of international adoption. Let me just say a couple of points on illegal adoptions and illicit activities. The illicit activities in respect of intercountry adoption include child trafficking, child abduction, child stealing, buying, selling, improper financial gain and corruption, private adoptions, falsification of documents, circumventing adoption procedures, for instance, through guardianship orders, and so forth, so forth. Again, if you look at the jurisprudence of the Committee on the Rights of the Child, we have commented on all these issues. For instance, in the context of use of guardianship orders, when Uganda came before the Committee on the Rights of the Child. We have commented in the context of the OPS when the United States of America came to us, and so forth, so forth. And these are addressing illicit activities should also be at the core of upholding the child's right to an identity. I leave it at that for now.
Thanks, Benyam. it's really important work that the committee is doing, but what do you think the committee can contribute to in moving reforms to address these issues based on the provisions of the convention?
Thank you very much for that question. We, as a committee, we often say we are as good as the information base that is before us. I'll give you a simple example. I've just returned from Geneva this week. We were in Geneva for 2 weeks. We reviewed the state party report of the Netherlands. And we received information about the commission that they had actually established, the report, some of the views from different stakeholders on that report, and some of the progress that's been made, but also some of the things that need to be made in moving forward. So if I was having a conversation with the government of the Netherlands before us, if I'm well equipped, then I can have a more nuanced conversation and I will feel confident. I mean, when you sit as a member of the Committee on the Rights of the Child, you're not going to become an expert on children's rights in 196 states parties, absolutely not. So the information base that is before you becomes critical so that you have a more nuanced, every I dotted and every T crossed kind of conversation with the state party. So the information base is absolutely important. You know, I'm not sure if I had mentioned this to you, but when intercountry adoption was reaching the climax numbers in the 2010-2011, there was more engagement on the topic. Now there is less engagement on the topic, but it's not because the abuses have died down. There are even much more nuanced ways. I mean, when you read some of these reports coming from different countries, commissions and investigations, you see that some of these violations have actually continued even today. So we shouldn't drop our eyes off the ball simply because the numbers have actually dropped. So we don't do this on the basis of the numbers. We do this on the basis of the fact that it's a human right and every individual's human rights, and in this particular case, child rights counts. So that's important. So we need to get the circle bigger. We need to have more engagement with the different stakeholders, including your own organization, to make sure that that engagement that we have with the states is nuanced. But you're also keeping us honest in the sense that we're saying this to you, but if you provide the information, we have to be able to actually engage with the states. Of course, there are internal processes within the committee, what questions to be prioritized and so forth. But again, as long as it constitutes an issue in the state, the very likelihood that it will be raised will be there. That's the first one. The second is the optional protocol on an individual complaints mechanism is giving us a lot of opportunities to clarify the obligations of states, but also the rights of children in the context of the Convention on the Rights of the Child. I mean, if it's like the optional protocol is putting flesh on the skeleton, as it were. You might have seen some of the recent decisions that we did, for instance, on kafala, on climate change last time, and now just in a short while you will get the opportunity to look at the decision that we made on children that were accused of being associated with ISIS fighters in Syria, and the responsibility of states to actually repatriate those children. So the opportunity that is presented by the optional protocol is absolutely huge. It's pushing the boundaries in a very positive way because, as I said earlier, and I'm repeating myself here because it's important, it's helping us to put flesh on the skeleton. So even though we don't go out looking for cases, I believe it's not going to be too late. It's not going to be in the too far a distance that we will be getting communications alleging violations of children's identity in the context of intercountry adoption. There may be some issues because, for instance, in some circumstances, the violations happened many years ago. The person is not a child anymore. Would the committee deal with this as it is a committee dealing with the age 18 as a cutoff, or would it constitute as a continued violation and so forth? These are obviously things that the committee will reflect on, but I have no doubt that in the context of intercountry adoption, in the context of the child's right to identity, I think we have an excellent opportunity through the OPIC. The third one is there are few emerging issues. Some of them, they've been there for a while. Some are maybe emerging. For instance, the link between surrogacy and intercountry adoption. What are some of them? The link between domestic adoption and, of course, intercountry adoption. Their implications for the child's rights to identity. The issue of baby boxes. Again, I come back to the Netherlands. Last week, we had a conversation with them about baby boxes. They said it's baby rooms. What's its implications for the child's right to identity? The digital environment. again, in the context of intercountry, I mean, issues of statelessness. We know for a fact that in the majority of instances, intercountry adoptions are not really based on nationality, it's based on habitual residence, but there have been examples where children actually became stateless as a result of the fact that we didn't get our I's dotted and everything crossed, and the institutional framework was not there. So some of the recommendations that we've also included in your brief definitely reflects the positions of the Committee on the Rights of the Child. And I do believe that we need to continue to engage in a more active manner to address some of these issues. I see the time is 5 minutes. Over to you.
Thanks, Benyam, for that. Definitely CHIP is committed to providing as much information that we have. And I encourage all the other participants listening today to also provide you with this ammunition, this flesh that you're talking about, so that you are able to do your work as even better and engage with the states. So thank you for your time, Benyam, and we'll be in touch. And now I turn to our next speaker, Professor Danius Pouras. He was also a Committee on the Rights of the Child member in the past, and more recently, the UN Special Rapporteur on the right to physical and mental health. He's going to speak to us today about the right to identity from a psychosocial perspective, which I think is very important, given that often people talk about just physical health, but because changing a child's identity in intercountry adoption fundamentally is linked also to the mental health. We're really privileged to have you here with us today. Danius, thank you for your time.
Thank you, Mia. Can you see my slides?
Yes, but maybe if you just do full screen and then it will make it bigger.
Okay.
It hasn't gone full screen yet, but it's okay. We can do it like that.
Are they moving? Moving?
No.
No?
They're not moving. No.
Oh.
Do you know what? Let's ask Gisela. She's ready. She can share her screen. No problems. And then you can talk. But good that we were ready for this. We knew that it was going to potentially happen. Thanks, Danius. But if I can ask you, the first question is, can you please explain the issues related to mental health and holistic development in intercountry adoption and the right to know one's origins?
So, thank you very much for this. I'm very delighted to be part of this very important webinar, and my contribution is mainly on mental health related issues. And also I will give some experience from regional or sub-regional perspective, which is mainly European and Eastern Central European experience. Can I have? Thank you. So this is the experience, mainly sub-regional, regional, and then serving as special rapporteur, which means a global mandate. And my priority, my focus was on mental health and modern understanding, also mental health of children. Next. So basic principles have been already mentioned by previous speaker, Benyam, a member of CRC committee. Just in my words and my understanding that it's very important to avoid selective approach to human rights and to human rights of the child, because if we go selective approach, sooner or later we fail. So like with adoption, also intercountry adoption, of course, the good idea was to increase quality of life and well-being of children, but at the expense of other rights, and including right to child's identity. So we always need to see all picture when we manage this very complicated process of adoption. Next slide. And we need to learn from lessons from other challenges. So again, each innovation, each social practices has two sides, pro and contra, and then we need compass, and the compass is human rights-based approach and child rights approach. based on CRC convention. Paradoxically, the role of family is huge and crucial, but a lot of bad things happening within families. And we are witnesses now of so-called fashion of traditional family values concept, which actually is harmful, threatens to health and development of the child as a member of a family. But also, I also wanted to remind to us issue of baby boxes. Sadly, at least in my sub-region, despite good recommendations of CRC committee to abandon this, let's say, harmful practice, I should say, nothing happened. I mean, all political parties and population, everybody is very happy about baby boxes, which means lack of understanding how important it is to respect human rights of the child, and especially right of the child to know the roots and origins. Next, please. So when we move to issue of intercountry adoption, you all know that there are risks, and this is why should be safeguards. There are very good guidelines which will be discussed today, but we know that in real life, rights of children to identity are violated very often. And from my perspective of mental health and emotional, psychosocial well-being, this, of course, may have harmful impact to mental health because it damages or may damage emotional, social, cultural development, which is precondition of good mental health. So intercountry adoption, with all its positive sides, increases the risks with regard to children's identity, and we need to take this into account and at all levels of decision making. Then the issue of secrecy or openness, I will elaborate on this later, but we all know from our lives and from mental health that hiding the truth always has its price sooner or later. So the children need to know what happened with them in their early childhood. And the question is not just whether to inform the child, yes, but the question is how to do this. So human rights-based approach and good management are needed, especially this is crucial when adults are facing facts of secrecy or illicit illegal adoption in their childhood. Next, please. And some experience from Europe, from my sub-region, may be interesting in this regard of learning lessons. In Eastern Europe and former Soviet Union, there were a lot of children in residential care for some ideological reason that the Soviet Union was hiding social problems and medicalizing them. So there were many so-called orphans, but they were not really orphans. They had at least one alive parent, but these parents were disempowered. They were told that they were good, not enough. So it was not about abandonment. It was about relinquishment mainly. And these all babies were in so-called baby homes for children with developmental disorders. This was an official title, which means that the state was the idea was to diagnose all them that they're patients, they're sick, they're disabled, even they were not. And then local families who wished to adopt, well, yes, they wanted a healthy baby, but they were told, no, we do not have. All of them are sick, all of them are ill, all of them are ill with disabilities. It was a strange medicalization of disabilities. So then families from other countries were coming and adopting and thus preventing from effects of institutional care. So this is good side, positive side of that story, but we see how many negative sides, this disempowerment of birth families and birth parents. So very slowly, after almost 30 years, only some years ago, in my country, in Lithuania, numbers of national adoptions finally exceeded numbers of international adoptions, and slowly local families received some incentives to adopt children, which I think is good development. Another important issue which I want to raise is cultural. It's improving now, it's changing, but still deeply entrenched thinking that it is better for the child after adoption not to know his or her origins. So it's very deep thinking, maybe from totalitarian system, that the more you know, the more unhappy you are. The less you know, the more happy you are. So of course, this is against good mental health, it's against human rights and human rights of the child. And I am happy that this kind of thinking is now not so prevalent anymore. So maybe this was my comment to some issues. And if we go further to mental health, to impact of issues related to adoption to mental health and emotional well-being. Can I have another slide? So I want to remind us a modern understanding of mental health. It's a lot of dynamics in global mental health and right to mental health. Good mental health is not just about absence of mental disorder. This is more about healthy development, emotional, social, cultural. And after 4 decades of dominance of biomedical paradigm, we know it's like pendulum. It was excessive use of psychoanalytic model. Then it was, I should say, excessive use of biomedical paradigm. And now I'm glad that global mental health is more and more interested in relationships, in social determinants of mental health, including the role of childhood events to health and well-being through entire lifespan. And then early childhood and adolescent are crucial, that child is a rights holder is crucial from very birth, and that children need supportive and enabling environments in all settings, starting from family, of course. Adolescence is very important, and adolescents want very often to discover their past, and adults want to do this. And this is all very much about self-esteem. So process of search of identity, autonomy, trust, and the way how you control your own life is crucial for mental health. And this is why all details related to process of adoption, especially intercountry adoption, are extremely important to mental health and well-being, because quality of relationships, as we know, that should be based on mutual trust and respect. And this is why things like secrecy, anonymity may be harmful to mental health. And my last slide, please. Thank you. So what could be possible effects from modification of child's identity through intercountry adoption? I will not speak much about impact of absent information on physical health. It may be an important issue, but I move more again to emotional, mental health. So we know that impact of absent information on health and development, such as identity, relationships, personal development, and it's crucial. And we know that many adopted persons, adoptees, they believe that access to their origins is a fundamental aspect of their identity building. And here I see also very interesting parallels with assisted reproductive technologies related issues, which we had very important seminars some months ago. Of course, special role of adoptive parents can be discussed, but more important, I think, is to speak about how people feel when they find out that their adoption included abuses, illicit practices, that information after long search is not available. Of course, this is detrimental to mental health. So mental health issues in adoptees may be related to traumatic experience. Yes, some professionals will tell that mental health issues may be related to brain damage or genetics, but I should warn against medicalization of these issues. Very often, mental health issues are related with adoption process itself, including the painful issues of identity and search of identity and origins. So adoptees confront existential questions about the how and why of adoption, as well as questions about their dual origins, identity, and sense of belonging. Of course, some can live comfortably, even with absence of very important information, but others, and I should say many, may be traumatized and seriously traumatized. When adoptees discover that their adoption involved abuses, illicit practices, this often triggers emotions, of course, such as feelings of anger, sadness, betrayal, and they may feel like they have been trafficked or bought, and thus this may have impact, first of all, on their self-esteem, which is crucial to good mental health. As always, when we move to questions, so what can we do to manage all these complicated issues? As always, first is prevention, and this webinar will be about prevention, which means for me that all good human rights principles should be observed and protected during the entire process. And second is post-prevention, is what to do when things went wrong during the process, and maybe the adoptee who is now already adult has all these traumatic experiences. So I think that if adoptee they have mental health related issue, first of all, we should not medicalize them. We should not turn them into mental disorders and some biomedical interventions. Sadly, this happens in current psychiatry. Of course, we should help, we should support, but supportive services not necessarily means some medical treatment. So if we, from the very beginning of this process and through entire process of adoption and after, and many years after, if we observe human rights-based approach, then we can expect to be effective. So I will finish with maybe conclusion that values, which means human rights-based approach to protect human rights of the child, and then good management, which is very important in this complicated issue related to adoption. So thank you.
Thanks, Danius, for that excellent presentation. It's not a new angle, but it's an angle that we don't give enough attention to, the mental health aspects related to intercountry adoption. And if I can have a takeaway from what you've said, is the importance of truth and transparency in relationships. And I think that is a good takeaway for us as we move on to the work of Capucine Page, from a legal officer from the Hague Conference on Private International Law. She'll be talking to us about the Hague Conference's working group on illicit practices. So Capucine, thank you for being with us, and would you be able to explain to us what is this working group?
Thank you very much, Mia. Yes, of course, I'd be very happy to explain the work of our working group. I'll briefly present the working group and then explain what has this group been doing over the past years. So this working group started in In 2015, it was decided to convene this working group after the 2015 Special Commission, where it was felt that it was really important to do more work on illicit practices in inter-country adoption. So we have this group that has been working on both preventing illicit practices and addressing illicit practices when they do occur. So our group has been meeting 4 times in 2016, 2019, and then again 2 times, but now online in 2020 and 2021. And so the objective of this working group have been to try to better understand how the illicit practices arise and how they can be better identified, so that you can try to see how you can then prevent them. Once you know how they arise, once you know how they are, once you have identified them, how can you prevent them? And then also try to see how to take effective steps when the illicit practices actually occur. So in trying to understand all of this and working on all of this issue, the working group has been developing practical guidance through different tools. And so these different tools are now all into what we've called the draft toolkits on preventing and addressing illicit practices. So I'll bring you through the different tools that the working group has been drafting. And that are now available on our website for comments. So we have fact sheets on illicit practices. We have 11 fact sheets, and each fact sheet is on illicit practice. So you have one on the abduction, the sale of trafficking children. You have one on financial aspects. You have some on the matching, on the prospective adoptive parents, on the misrepresentation of identity. And so with each of these fact sheets, the idea was to assist in better identify and recognize the illicit practices that happen in inter-country adoption. So if you look at on the left, I've added a picture of one of these fact sheets. If you look at the red column, these are different illicit practices that can happen. And then the group has also tried to identify possible enabling factors. And these are not illicit practices, but these are factors that can enable the illicit practice to arise. And this is what you see in orange on the left. So it's, for example, not having a law or procedures. It's not illicit in itself, but if you don't have this, it might lead to a situation where it's easier to abduct the child, where it's easier to sell the child. And then what you see on the right, these are possible preventive actions. So measures and safeguards that states can take to try to prevent the illicit practices and the enabling factors to happen in the first place. Then we have another tool. It's a checklist that is mainly intended for the central authorities and the adoption accredited bodies. And so on this fact sheet, for each step of the inter-country adoption procedure, there is a list of issues that the authorities should watch out for. So for example, if you take the first step, that is to verify the identity of the child, it's important to verify the documents and verify the information. And there is also a list with the action to take. So if you verify the documents and if everything seems to be correct, then you can go to the next step. If there are things that looks not well, that there might be illicit practices, then it will give you other actions to follow before you can move to the next step. Then we have also another tool that is a model procedure on how to respond to the illicit practice. So here it's not about preventing, but what to do when the illicit practices did occur and how you respond to them. And so this model procedure has different steps, and it's here to to respond to illicit practices that may happen in individual cases, but also in cases where you would have a pattern of illicit practices. So even though you may have a pattern, each adoptee that has been a victim of the illicit practices, part of this pattern need to have a solution, and you need to respond to each of them. So this model procedure is here for all these cases to assist on how to respond. And then we have a final tool that is much shorter on providing guidance on cooperation and coordination between states. And it's also, these guidance are for both preventing illicit practices and also for addressing them. And one example might be if you have, if there has been a pattern of illicit practice in a state, it's important that all the other states can come with the same and a clear message. If each state has a different message to send, it will be harder for the illicit practices to stop. So it's important, for example, that all the states can cooperate and send a strong and coherent message. So I'll stop here. Thank you, Mia.
Thanks, Capucine. That was a very clear explanation of the work of the working group. And I have a specific question. How is the toolkit addressing the preservation of the child's right to identity for the purposes of the webinar?
Yes, thank you. Of course, it's also the toolkit. Some of the tools do address the preservation of the child identity. I thought I would give you some examples that are in different fact sheets. So I'll go through some of these. Of course, it's not exhaustive, but just to give some ideas. So we have, for example, a fact sheet on the misrepresentation of identity. And there, well, one of the illicit practice might be, for example, when a person is pretending to be the parent of a child and then give the consent to the adoption of that child when they're not the parents. And then something that can enable this illicit practice would be, for example, if the authority are not verifying the identity of the child or the birth parents, or they're doing it but not very well. This in itself is not illicit, but it can clearly lead to situations where someone can pretend to be a parent and you let it happen. Possible actions to prevent would be to try to implement, to enact and implement legislation and procedures to know how to best verify the identity of the child and the birth parents. Another example would be when if someone is lying about the date of birth of the child, because then you might not know which child is actually in front of you. And something that could lead to this illicit practice would be, for example, if you don't have a strong birth registration system, or if not everything is working well. For example, if you have to pay, or if the register is really far, or if sometimes some persons are victim of discrimination, they may not be allowed to register the birth. So in order to prevent this, it's important to have a strong birth registration system that is free, where it's mandatory to register the birth, that is efficient, that is non-discriminatory, and that is easily accessible. And so by having this preventive action, the idea is to try to really preserve the identity of the child. I'll give another example with another fact sheet on forgery and falsification of documents. One other illicit practice would be to use forged documents, and in which the identity of the child would be a false identity. And an enabling factor would be if you are actually not reviewing these documents. So you may not see actually that the document is a forged document. So if you want to prevent this, then the fact sheet propose some measures to take, that be for the authority to really verify and confirm the source of the information that is in the documents. Also really review, really scrutinize all the documentations. And if, for example, you have different documents where the date of birth, for example, of the child is in different documents, to really ensure that in all these documents, the date of birth of the child is the same, to ensure that there is no inconsistencies between the different documents. And now I'll speak about a last fact sheet that also addresses the preservation of the child identity, and is a fact sheet on the preservation and the access to information. And of course, there is an article in the convention that it's important to preserve the information and to provide access to this information to the adoptee. So an illicit practice would be if the authorities are not doing this. And a possible enabling factor would be if there is no legal framework on the preservation or the access to information, or if this framework is not really adequate. It could also be if the person that are supposed to assist and to guide and support the adoptees in searching for the origin, in accessing their information, if this person are not providing the appropriate guidance, or if they are not well trained. So possible actions to prevent this would be, well, to implement legislation on the preservation and the access to information. Also making sure that all the information, but not only the information, also the belongings of the child are really kept, and they are preserved in perpetuity. So forever. The idea is not that after 20 years, the information can be destroyed. And so if the adoptee wants to look for the origin after that they don't have access to this information anymore. So try to preserve it forever. Also, possibly establish and implement guidelines on counseling the adoptee, and train the persons that will provide access and assist the adoptee in searching for their origin. So these were some of the examples on how the toolkit is preserving and trying to preserve the identity of the child. Thank you, Mia.
Thanks, Capucine. We really look forward to having the finalized version of the toolkit so that we can disseminate and get not only states, but also all other adoption stakeholders to use them and to implement them for the preventative and the responsive side. Thanks for your work. And now I turn to my two colleagues, Cécile Jenner and Christina Baglietto, both working at Child Identity Protection, who will speak to you about what are the key conditions to ensure the proper modification and preservation of the child's identity in an intercountry adoption. Thanks, ladies.
Hello and good afternoon, everyone. I hope you can see our screen. Yes, good. So what Cécile and I will do is talk about the child right to identity, specifically on modification, preservation, and the risks of falsification. I'll start with this one. There you can see a brief paragraph from Lee Kyung-Yoon, who is the Director of Human Rights Beyond Borders, and which really reflects the lifelong impact of a change of identity for children, adolescents, adults who have been adopted internationally. And also it really reflects that there's no unique way of feeling towards one's identity, and also of no contradictory feelings towards one family or another. So I think it's really an important starting point for our presentation. The main point is really that intercountry adoption entails a profound modification of a child's identity. And in that respect, Article 8, as mentioned by me at the beginning and some of the other speakers, is the key article of the Convention on the Rights of the Child, which talks about the right to identity. And it really has two elements to it. The first one is very well known, which is the right to identity, the right to nationality. But then we have the family relations bit, which is not as well known as the other elements of the right to identity. And then the second part of the article is even less well known, and it's the obligation to re-establish identity when there are missing elements. So that's in that context really that child identity protection promotes and intends to protect the right of the child to identity by focusing on various situations of this right to identity. Well, the creation, which I said is probably the most well-known, the most visible aspect of the child's right to identity, but we also very much work on all situations relating to the modification of the child's identity, the preservation and the falsification, which in the webinar today we will really focus on intercountry adoption, although as Mia said, there's many other situations where this may happen. And then finally, obviously, we really want to make sure that in any of these cases, when there are missing elements, the child's identity is actually restored. So our presentation today will focus really on modification, preservation, and falsification. And I'll turn to my colleague Cécile, who will start this presentation, and I'll see you again at the end.
Hello, everybody. So to begin, we would like to focus on the fact that the modification of the identity of the child through an intercountry adoption should only occur when it is in the child's best interest, as mentioned very well this morning by Benyam. So the process of evaluating and determining the best interest of the child is crucial, and it deserves the full attention of governments and professionals that need to be adequately equipped and trained in this field. For example, to the material of the UNHCR, the Guide on the Determination of the Best Interest of the Child, that has been very recently updated. And this was also highlighted by the Inter-American Court on Human Rights in its judgment in the case Ramirez Escobar versus Guatemala in March 2018, where the court stated that authorities in charge of allowing an intercountry adoption should ensure that its option is the ones that best serve the interest of the child in terms of the individual circumstances of the child, the definitive separation from his or her family, and the consequent break with its national and cultural identity. And this is fully in line with the Article 20.3 of the Convention of the Rights of the Child, that states that when choosing a child protection measure, due attention should be paid to the continuity of the ethnical, religious, cultural, and linguistical background of the child. And this has been reflecting in some national laws, like for example, in Paraguay or in Ecuador. Another important aspect to take into consideration when evaluating the best interest of the child is the respect of the double principle of subsidiarity, which is also very important for the preservation of family relations, which, as mentioned by Christina, is an important part of the identity of the child. So authorities should ensure that all the efforts have been made to locate, reintegrate, maintain the child in his or her family, and when it was not possible, that national adoption has been promoted over intercountry adoption. Another important element also mentioned by Benyam this morning is the prevention of statelessness for adopted children, another important part of the identity of the adopted children. So according to Article 5 of the 93 Hague Convention, states should ensure that all the adopted child will be able to enter and reside permanently in the receiving states. And the 2005 Special Commission recommended that the nationality of the receiving state should automatically grant it to the adopted child. But as mentioned this morning, it's not always the case in practice, and some adopted person can become stateless, for example, in case of adoption breakdown, or when some states failed to complete some administrative procedure. And even in the country where normally the nationality should be automatically granted to the adopted children, like for example in Australia, New Zealand, or Norway, there is still some procedure to complete. So we can see that the identity of the child will change. His name, sometimes his surname, the name of the adoptive parents will be added to the birth certificate of the child. So it's very important to record and preserve all this information ideally permanently. How? Well, through the Service of Civil Registration and Vital Statistics, but as mentioned by Capucine this morning, there is a lot of practical obstacle in terms of mechanism in those services to record and preserve all this information, and also in terms of access, for example, for people coming from rural areas or people coming from indigenous community or with a low education. In certain countries, costs are requested, like for example in Uzbekistan, or legal document, like for example, marriage certificate in Indonesia. So there is still a lot of obstacle, but we can mention a lot of improvement. For example, in the state of Victoria in Australia, they have enacted the integrated birth certificate, where on the birth certificate of the adoptive parents, the name of the adoptive parents and of the biological parents are registered. We can also mention the Convention number 34 of the International Commission on Civil Status that allow for a much better portability of birth records across border. We can also mention, thanks to the sustainable development, by 2030, every person should have a legal identity. So a lot of countries are currently undertaking actions to improve the access to birth registration services. It is also worth to mention the work of the UN Legal Identity Agenda to promote the right to a name and nationality for every person, and Child Identity Protection is collaborating to these international efforts, focusing on another key element of the identity of the child, already mentioned, family relations. And those family relations are very important in the context of adoption, inter-country adoption, because they will change. So it's important to preserve and to keep all the information on the family origin of the child. And this means not only the name of the member, so all the information regarding the life of the child previous to his or her adoption. Like, for example, the circumstances of his birth, the circumstances of his potential abandonment, the documentation on all the efforts made to locate the family and maintain the child in his or family, social reports in case the child has been placed in foster care or institutional care, medical information, as mentioned by Danius Perez, is very important to detect and address some disease. So we can see that any gap in this information can create difficulty in the life of the child and later the adult he will become. So each of the elements we are mentioning since the beginning of the morning are very important for the construction of the child as a unique person, and we enable him to answer at least partially to the existential question, who am I? And I turn the micro to Christina.
Thank you, Cecile. So yeah, as mentioned at the beginning of the presentation, if we focus on the various situations of the child's identity and potential changes, as reflected by Cecile, there's a need to ensure that modifications are in the best interest and that all information is preserved. However, we all know that there's situations where the information is actually falsified and there's even sale of the child's identity. So to finish this presentation, I'll really focus on that particular situation of falsification. There have been countless numbers of children being illegally adopted in more or less publicized cases over the years. Many of the well-knowns are Guatemala, Nepal, Vietnam, but there are many others which are not as publicized, but are just as serious and sometimes systematic as well. In these situations, the identity of children have been falsified and are sold to facilitate adoptions. And when we talk about facilitating adoptions, it's illegal and unethical adoptions, not compliant with international standards. Prior to the Hague Convention on Intercountry Adoption, many of the examples of the years prior to 1993 are the ones who actually led to the convention. And the convention therefore intended to respond to these situations by ensuring how can children be protected from being adopted through fraud, duress, or for monetary reward. However, even after the convention, we still have many examples, including the ones I mentioned earlier. Amongst them, the paper orphans, which is the term used by David Smolin, who's also going to be talking later on this webinar, and which he defines as child laundering when children are illicitly obtained by fraud, force, or funds, and then processed through false paperwork into orphans and then adoptees. In other words, they're orphans on paper, but not in reality, to make it a short version. What are the factors and means of falsification of identity in intercountry adoptions? Here, I would like to mention many of the examples that Maud De Boer included in her report in 2017. She will also be talking, so I'm hoping I'm not putting words into other speakers, into my words. So many of the factors and the means are the luring of biological families into placing their children into care. It's the attraction of families and explaining that care is much easier, it's much better for the children, and that will slowly keep the children in care and then potentially take them into adoption. The lack of proper consent of biological families, including coercion and flawed procedures, but not only, sometimes it's not explaining well what the consent means. Sometimes in writing, families cannot always read or write. So there's a lot of linked issues to a lack of proper consent of biological families. Obviously, there's all situations of abduction, sale, and trafficking of children by criminal networks. The improper profiteering by a range of intermediaries. When we look into intercountry adoption and intercountry adoption systems, we all know there's a range of intermediaries involved in the procedures, and we can see that there might be profiteering from several of them, if not all of them. Obviously, as mentioned earlier by Capucine, the poor legislation or standards relating to adoption obviously open a path to potential abuses. And not only in adoption, but also when there's a lack of solid legislation or standards in care and also in criminal offenses, when there's not enough response from the criminal system. Obviously, political grounds and motivations, in particular in emergencies and some political regimes, we have a lot of over the years, there's been a lot of situations where this has happened, Argentina, Chile, and many others. Legislation also, when there's not solid legislation, not only in the care and adoption standards, but also when it's permissive on the modification of identity. For example, legislation which allows the secrecy of adoption. So there's a lot of loss of information and potential falsification of the child's right to identity, and obviously deficiencies in the general child protection system. As mentioned by Danius earlier, there's a lot of impact of the changes of identity, and when we talk about falsification of identity, you can only imagine how much stronger this is, because there's a real deprivation of fundamental elements of the adoptee's identity. It's difficult or nearly impossible to have access to origin or to know one's family origins. The complex restoration of the child's identity, when I mentioned at the beginning the importance of restoring the child's identity when there's missing elements, when there's falsification, this is very, very complex, if not impossible. And then the lived experiences, which you will hear from other persons on this webinar who have experienced these situations, reflect not only the impact of falsification early on in the life, but the lifelong implications this has, and therefore the real need for prompt restoration of the identity. And finally, here I would just like to mention some of the key conditions which we see to ensure the proper modification and preservation of the child's identity in intercountry adoption. As mentioned by Cecilia earlier, the modification should only occur when it's truly in the child's best interests. I think that's central for all adoption procedures. And key indicators that this is in the child's best interest and is that it also meets the identity needs. So there needs to be prevention, subsidiarity of the adoption, the necessity and suitable options for the nationality, etc. Therefore, states should ensure that full records are kept of any modification to the child's identity and that they're accessible in perpetuity, as mentioned also by Capucine. I think this is something very important, that the information is not preserved only for a certain amount of time, but really for forever, because we have also had the experience of not only adoptees looking for their origins and for their identity, but also grandchildren we know now, or other family members who might want to look into their parents' or grandparents' origins. Therefore, states should ensure that proper mechanisms are in place to prevent and sanction any sale of children, illicit practices, falsification, and to avoid the child's commodification in intercountry adoption procedures. And finally, where sale and or falsification of the child's identity has indeed occurred, states should work speedily towards reestablishing the missing elements. And I think that will be at the core of another session on today's webinar. So I'll leave it to those experts to take us through that element. Thank you very much.
Thanks, Cecilia and Christina. It's very clear that the child's identity being such a fundamental part of who they are should only be modified under the conditions that you have mentioned that are included in CHIP's policy brief. And so thank you for presenting that to us today. And now it's my great honor to also present Ina Digard, a Danish adoptee from Sri Lanka, and also the Vice Chair of the Adoption Society Board. She will explain to us her own background and also the approach of the Danish authorities in terms of pre and post adoption training on the issues of identity. Thanks, Ina. For the first question, I wanted to ask you just to firstly perhaps just introduce yourself and give us a bit about your background.
Yes, I will do that. I will just share my screen and find my presentation. So, hello everybody. My name is Ina, and today I will talk about respecting the child's right to identity in intercountry adoption from the perspective of an adoptee. And I will start by saying that it is a little bit of a difficult task in many ways. A personal story is much more difficult to tell online than in real life. But also because a personal story is unique. My perception of intercountry adoption is built on my personal experience, of course, but also professional experiences as working at Adoption and Society and being the former post-adoption coordinator at Danish International Adoption. I will share bits of my personal story, and after that I will talk about the Danish system. I was adopted when I was 6 weeks old. I was a little baby. I was born at a hospital in Colombo, Sri Lanka. I lived with my birth mom until the day we went to court. In Sri Lanka, it's mandatory for the birth parents to show up in court. So my parents have met each other. It's weird because that moment was the happiest moment in my adoptive mother's life. That was the way we always talked about that specific moment. But when I met my biological mother in 2013, I discovered that it was also the most devastating moment. And I never really thought about that. So I was a baby when I came to Denmark. My mom was a single mother. I will get back to that. But when I was a little girl, she met my dad. I was adopted by my father when I was 10 years old. So part of my story and my identity has always been that I was lucky enough to have 4 parents and also being adopted twice. My birth dad is unknown. I was raised with a story about my dad, my birth dad, but getting older, I doubt it was the truth. When I met my mother, she froze completely when I asked her about my birth dad. I was born in wartime. There was a civil war in Sri Lanka. And I wonder if I could be the result of a rape or if my dad was possibly a soldier, but I will never know. I grew up in a Danish suburb, living a completely normal life. When I was 8, my parents adopted my little sister from China. So we are indeed a mixed family in many ways. And as you can see, my little daughter, Sophia, she's also mixed with Danish and Sri Lankan heritage. My personal story is that I found my birth mom in 2013. I traveled to Sri Lanka with my dad to meet her. And it was a great experience, but very strange also to walk along the Indian Ocean and be so far away from home. I have never felt Sri Lankan, and I didn't really connect to Sri Lanka when I was there in Colombo. And I actually never felt more Danish in my life, and I just couldn't wait to get home. No one in my birth family knows about my existence, except my mom and my uncle. I have 2 big sisters. I have nieces and nephews, but no one knows about their aunt in Denmark. Every bit of contact with my mom is a secret. She only calls me when she needs money. I have been quite disappointed because it wasn't that kind of relationship that I wanted when I tried to find her. It's complicated and it's tough. And if I'm being really honest, I sometimes regret that I found her, because it sounds so awful, but it's actually the truth. And it's complicated because I found a person that looks exactly like me. We really look like each other. But otherwise, I can't identify myself with her. We don't share the same values, and the way she's acted towards me is much more hurtful than anything else. It used to be quite emotional for me whenever she contacted me. But at the moment, it's becoming more a stress factor, and it's something that I really don't want to deal with. For example, the last 2 weeks, she's been calling me for over 20 times, and my daughter was hospitalized, and I wrote to her that I couldn't talk because I was in the hospital, but she just kept calling and calling and calling. And I know she wanted something, but I used to become really, really, really sad and really emotional, but now I just try to keep a little distance to her. And that's really difficult, because that wasn't my dream when I started looking for her. So that is really difficult. So I shared some personal pictures. It's my dad, you can see in the corner. And the other picture is a friend of mine that I met in Sri Lanka. It was a great experience, but it was also really, really difficult to go back there. Yeah, so we'll change the subject a little bit and talk about openness in adoption. Because I think some of you, I know, you know about the many stories about intercountry adoption in Denmark. Amy, Marcion Roba, and many other cases. We all learned a lot from those stories. But one of the most important things is how openness is key. There are many ways to talk about openness in adoption, and there are definitely other speakers in this room that are better and they can explain it in better ways than me. So I won't talk about that, but I will try to reflect a little bit about openness in my own adoption. In my adoption papers, there is an original birth certificate, my mom's name and address, documents from the court, and many other things, like a photo of my mom being adopted 30 years ago. I know I'm really, really lucky. That is also a kind of openness, but I never felt it that way. I was just, it was just a part of me. That's what I was brought up with. It wasn't really a special thing. And if you ask me, in my perspective, it is the adoptee's right to know at least the content of the adoption file, every kind of information. And I'm really amazed sometimes when information about the adoptee is considered some kind of openness, because to me, it's just a part of who we are. It should be accessible for every single adoptee without discussion. My mom, she created a photo album from Sri Lanka. All my life, it was placed in the living room. So whenever I wanted to look at pictures from Sri Lanka, I knew where to go. They were never hidden or a secret or something that we couldn't talk about. That is also a kind of openness. I know a lot of adoptees that couldn't speak about their own adoption in their own home with their parents. That is just heartbreaking. We know that openness in adoption is key to having a safe attachment to the family. Respecting the child's identity with whatever is involved contributes to a much more calm and safe upbringing, if you ask me. The level of openness is individual, but Danish research showed that the adoptees would benefit from a higher level of openness if it was adopted after 3 years compared to an infant. Many parents ask me how to do it and when to do it, and I don't have the answer of that. But I think one of our greatest tasks as parents is to observe and follow the child's needs. If we want to respect the child's right to identity, which we should, the information from the adoption file, such as birth certificate, court orders, etc., must be accessible for every single adoptee in the world. No secrets or hidden information. We should also reflect on which kind of information we actually put into the files. Especially when parents are unknown. Even though we might not know who the birth parents are or other family members, the child has a story and there's always something to tell. Where was the child found? Take pictures of that place. Pictures of the surrounding area, get a statement from the person who found the child, stuff like that. In that way, the child gets a part of an history. And I believe that this kind of openness makes it easier to grow up in an adoptive family and will prepare children for whatever challenge they might be confronted with, especially racism. Racism plants insecurity and doubt and many other things in us. We feel less worth. We feel that we don't belong in the society, but we do. And knowing who I am, where I belong and where I come from makes it a little bit easier to cope with.
Thanks for the privilege of hearing your story and the honesty and the transparency. I hope that we can all work together to ensure that these files and they are also as transparent as you have been. And if you could now just speak to us about how the Danish model tries to incorporate the issue of identity in the pre-adoption and post-adoption phase, that would be great. Thanks.
Yes, I will try to do that. Our approval system is divided into 4 phases. And phase 2 is a mandatory preparatory course. The course extends over 2 weekends, and the purpose is to qualify the applicant's decision on adoption. That includes stories, cases, movies, discussion, etc. And they are guided by 2 post-adoption counselors. The course makes the applicants reflect on their motive behind choosing adoption, their own upbringing, and what they bring into their upcoming parenthood. It also aims to inform the applicants about the special way to become a family, because it is. It also informs how should I describe it, that the child's story and the child's term is something special, that they should, the birth family, whatever the story might be, it is special and it's something that they should take really good care of and care for. So transparency is key. I actually asked our central authority how identity is a part of the course, and it's really difficult to answer actually, because identity is kind of a part of it all. But I think it's really good that the parents are prepared and knows how special it is to adopt, because it is a quite special way of becoming a family. This course didn't exist when I was adopted. A lot of our critical voices are grown-up adoptees like myself. And the truth is that our parents weren't prepared and they weren't screened in the same way as they're being today. Then there is phase 4, and that is quite new. It includes counseling with a post-adoption counselor before and after becoming a family. After you accept the match with the child, you have to participate in 3 hours of counseling. The focus is the applicant's own thoughts and feelings about the adoption. Some applicants have been standing on the waiting list for quite some time. So it can be quite overwhelming and to finally becoming a family. And on the other hand, others have waited for a very short time of period. And that can be overwhelming too, because you have to adjust really, really quickly. And after becoming a family, the parents have to participate in 3 hours of counseling again within the first 3 months. And here the focus is, of course, the new life as a family. This phase is actually something that we fought for a long time. And we know that our central authorities, counselors, are very professional. And we have such a well-developed pre- and post-adoption service. So this is simply a qualification of the approval system. Furthermore, we believe that this way of being prepared just before traveling and talking to a counselor after coming home hopefully minimize the amount of potential breakdowns. And then there's the last thing, which is the post-adoption service. In Denmark, we have a quite well-developed post-adoption service. This includes counseling for children, group counseling, free courses for professionals, teachers, social workers, etc. It's for free, and counseling for adoptive parents and for adoptees. Yes, and especially the counseling for adoptees is something we fought for in a very long time, and that we're quite proud of, because adoptees, they also need counseling in special periods of their life, becoming parents or searching for birth families, having identity issues, stuff like that. So we are very, very happy and humble that we have such a wide palette of different kind of services in Denmark. Let me see. I have a personal example, because I've used counseling myself, so I know what I'm talking about. I've done it.
Maybe Ina, I'm just conscious of the time, and people might be getting a little bit hungry, but so if you have a few more minutes to wrap up, that would be great.
Yes, okay.
Thank you.
I will delete my personal example and then maybe just go on to the, because you asked me to talk.
Yes, I did ask you to. Thanks.
I will do that instead, because I do believe in intercountry adoption, and I do believe that it belongs in the future as well. But we are also obligated to take all the things we've learned through time, the scandals, the cases, everything we learned. We need to take that into consideration if we want intercountry adoption in the future. So I think it's really important to have a well-developed approval system. One of the most important things is to have a system that is balanced, strict enough that we screen and that we know that the parents are qualified to become adoptive parents. But it's also important that they are prepared for becoming a family, either in quite some time or actually in very short period of time. And then, of course, it's key that we have post-adoption service. If we want intercountry adoption in the future, it is necessary that we have a support system, and that's not just for adoptees, it's for the whole triangle. I think that could be my last word.
That's an excellent last word, and I hope that the states that are listening take that on board. I know many have implemented post-adoption services. But like you said, this counselling for adoptees, the older ones, is very, very important. So thanks, Ina, for that. I see that we are running just slightly over Swiss time. We're supposed to start our next session in 3 minutes. But what I suggest is that we start the next session at 1:05. And if you have a little break now, we'll stop the presentations for now. Presenters, you can turn off your cameras, or we'll have a little break and we'll start again at 1:05, so in 8 minutes. Thanks to the first panel. I really enjoyed all your presentations. They were very, very complimentary and lots of thoughts to take away. Thanks everyone, bon appétit. Turn to our this next session, and this next session is really talking about the restoration of identity. What we saw from the first panel is really the importance of preserving identity. This session talks about what do we do if there are missing elements? What do we do if there are falsified elements? We have some responses from the expert panelists that we have here today. One of them being Mariella Colleen Fannin. Unfortunately, she could not be with us today, but she has provided us with this recording. Unfortunately, the original recording was the quality and sound wasn't great. So what I suggest is that you put up your volumes to absolute maximum. There are subtitles that we've added. She speaks to us. She's a Belgian adoptee, and she has a lot to say about the different efforts at the UN to restore identities. So without further ado, I'll ask Gisela to start this video. Thanks, Gisela.
Donc voilà, je vais un petit peu vous présenter Racines perdues. Donc Racines perdues a été créée en 2017 en tant que collectif. Ensuite, c'est devenu une association de fait. Et puis ensuite, une fondation en 2021. Une fondation avec un numéro d'entreprise, avec des statuts. Et nous sommes inscrits au tribunal de commerce et nous sommes soumis au régime des entreprises du droit belge. Donc avec évidemment toute une équipe au sein de la fondation, donc comptable, secrétariat, présidence, mais aussi administrateurs généraux et également évidemment un pôle juridique, des avocats, etc. Donc Racines perdues, au début, ça a été créé pourquoi? Pour la première raison, c'était créer du lien. Créer du lien, et malgré que voilà, le Covid ici nous en empêche, c'était d'organiser des réunions, des moments pour toutes ces personnes qui sont en quête de leur identité. Donc pour reconnecter avec leurs racines, leurs origines, présenter différents événements, présenter des activités en lien avec leur identité. Et puis on s'est rendu compte assez vite qu'il y avait toute une partie recherche des origines qui prenait une partie importante de cette reconnexion avec soi finalement. Et donc cette partie recherche des origines nous amenait également à deux autres problèmes, à savoir l'encadrement en termes de RDO, donc la fameuse recherche des origines, l'orientation, l'accompagnement qui n'existait pas en fait officiellement, légalement, juridiquement, au sens propre du terme, il n'y a pas de législation en vigueur. Donc nous, ce qu'on fait, on a dû le créer, on a dû entamer des protocoles, les inventer, se réinventer, les utiliser, les adapter en fonction. Et donc on s'est assez vite rendu compte aussi du nombre et de l'ampleur des adoptions illégales dont pouvaient être victimes certaines personnes. Il est évident que voilà, c'est une thématique qui dérange. On ne pouvait pas parler de la manière dont je vous parle aujourd'hui d'adoption illégale, on ne pouvait pas en parler de cette manière il y a encore 2, 3 ou 4 ans, c'était pas possible. Et donc il y avait vraiment ce souhait de pouvoir accompagner ces personnes, les aider du mieux qu'on pouvait, mais aussi de trouver des solutions. On s'est dit, bon, on est confronté à un problème, donc il va falloir sensibiliser, dénoncer, informer, et ça c'est vraiment les maîtres mots de la fondation. Sensibiliser, dénoncer, informer, pour essayer d'élargir le public auquel nous nous adressons. Et donc, on a effectivement entamé des plaidoyers. Donc, ça a été de la sensibilisation auprès du Tribunal international de droit privé de l'Haye. On a eu la chance d'être entendu grâce à Linel aussi, qui est de ICAF, qui est présente. Nous avons eu la chance de rencontrer Laura Martinez et Capucine Page, qui sont également présentes sur ce webinaire. Donc, il y a vraiment un travail de réflexion commune qui a été entamé. Ensuite, nous avons essayé auprès de différents gouvernements, autant auprès de la Belgique pour commencer. Ça a pris du temps, ça a pris beaucoup de temps, mais on a réussi à venir toucher, j'ai envie de dire, presque le cœur d'un député fédéral, parce que c'est pas politique, c'est un député qui est un ancien journaliste d'investigation, qui a été touché au cœur par les histoires de plusieurs personnes du Sri Lanka, de l'Inde, du Chili et aussi du Guatemala, qui a décidé vraiment de s'investir de cette cause, de proposer et de réfléchir à une solution. Et donc, il a proposé une résolution parlementaire qu'il a déposée en juin 2021. Elle a été prise en considération devant la Chambre des parlementaires en septembre 2021 et elle a été présentée ici en janvier 2022 devant la Commission des affaires extérieures, donc c'est-à-dire la commission qui s'occupe de cette problématique. Donc, on a présenté, évidemment, ça c'est la partie politique. Racines perdues est une fondation internationale, donc on a des administrateurs de différentes nationalités. On a aussi un pôle français, qui évidemment a un œil très attentif sur la décision du secrétaire général de la protection de l'enfance, M. Taquet, qui a déposé une demande de mission interministérielle pour l'ouverture d'une commission d'enquête sur les adoptions illégales. Donc évidemment, à notre niveau, on est en contact avec les différentes associations de terrain qui font un travail remarquable en France à ce sujet. Parce que aussi au niveau européen, on a fondé tous ensemble avec des Français, avec des Belges, avec des personnes hollandaises, un collectif qui s'appelle United European Adoptees, qui demande cette reconnaissance des adoptions illégales au niveau de l'Europe, mais pas que, parce que c'était vraiment une problématique qui n'est pas normale en 2022 qu'une personne adoptée, par exemple, je ne vais pas prendre le Guatemala parce qu'on n'est pas concerné, mais je vais prendre le Sri Lanka, une personne adoptée du Sri Lanka en Suisse soit reconnue victime et ne le soit pas en Belgique ou en France. Il y a une cohérence, quelque chose qui n'allait pas. Et aussi, une racine perdue donc, a été entendue auprès des Nations Unies devant le comité des disparitions forcées et devant le comité du groupe de travail des droits de l'homme. Donc il y a un comité du groupe des droits de l'homme, du comité des droits de l'homme, je vais y arriver, qui travaille sur la question des disparitions forcées et évidemment sur la présentation, l'audition qui avait été réalisée où je me suis rendue pour représenter Racines perdues en compagnie du député fédéral belge Michel de Magde pour expliquer lui son axe politique et nous notre axe plaidoyer au niveau de la fondation dans le cadre justement de cette réflexion du cône sud, donc de l'Amérique du Sud et puis je vais y venir dans une réflexion plus internationale. Donc la restauration identitaire, le droit, l'accès aux origines est quelque chose de fondamental et d'essentiel pour nous. C'est quelque chose qui doit être gratuit. C'est un droit qui fait partie, comme c'est mentionné dans la Convention internationale des droits de l'enfant, qui fait partie d'un droit acquis, un droit universel. Et donc pour nous, c'est important que ce droit reste gratuit, que jamais, au grand jamais, quelconque problème financier ou quelconque mesure, même notion financière, viennent interférer dans ce droit humain. Pour nous, c'est intolérable. Et c'est à ce titre-là aussi que nous avons nous avons présenté la thématique des adoptions illégales d'un point de vue stricto sensu juridique, d'un point de vue pénal, d'un point de vue droit civil, d'un point de vue droit technique. Nous proposons plusieurs choses, à savoir une étendue de la prescription des faits au niveau de l'adoption illégale. Donc là, pour nous, c'est vraiment quelque chose qui est nouveau parce que ça n'existe pas en droit dans plusieurs pays européens. Il y a cette connectivité de corrélation aussi avec le droit criminel en matière d'enlèvement. Mais enlèvement veut dire aussi une prescription qui démarre au moment généralement de la prise d'effet qui a une durée de 10 ans avec un effet parfois en mesure de support de ce qu'on appelle les interruptions de prescription. Mais bon, ça c'est très technique. Mais nous, vraiment, ce qui nous tenait à cœur, c'était de pouvoir se dire que en fait, ce fait devenait imprescriptible. Et donc, c'est aussi dans cette démarche-là, en allant vers les Nations Unies, on a eu cette chance aussi au niveau de la restauration identitaire de pouvoir présenter la thématique, les problématiques auprès de l'ONU, de pouvoir spécifier et expliquer quels sont aussi les enjeux. Alors d'un point de vue de recherche des origines, pour nous, ça nous semble essentiel. Il faut apporter des solutions, qu'elles soient ADN, qu'elles soient avec un traité international, qu'elles soient avec une déclaration universelle. Il y a des choses à faire en matière de recherche des origines pour les victimes. Il y a des victimes qui ne retrouveront jamais leur famille. Pour nous, par exemple, Racines Perdues, on travaille avec des partenariats. Alors on appelle ça les tests ADN récréatifs. On n'a pas de partenariat avec eux, mais on analyse effectivement et on se fait expliquer parfois et aider les experts, par des experts, les analyses génétiques. Mais aussi on travaille par exemple avec la Fondation d'anthropologie au Guatemala qui, elle, récolte les ADN prélevés sur les personnes décédées retrouvées dans les charniers, mais également possède une banque ADN comparative avec les vivants qui recherchent leurs victimes. Donc ça fait 3 bases de données, les dépôts des adoptés, les relevés sur les fosses, dans les fosses et les relevés sur les vivants. Et tout ça font qu'on peut faire des matchs. Mais pour ça, il faut évidemment, voilà, c'est du travail avec une finalité, une utilité publique, mais que nous avons décidé d'entamer, nous, Racines Perdues, pour permettre à un maximum de personnes adoptées de se reconnecter. Mais encore une fois, ça aussi, c'est ce qu'on explique aux Nations Unies. On ne peut pas y arriver sans l'aide des institutions, des organisations, avec nos petites mains et en plus de ça, avec une logistique qui est la nôtre, c'est-à-dire des moyens humains et pas des moyens très conséquents. Donc ça, c'est quelque chose qu'il ne faut pas perdre de vue en matière d'identité, de restauration identitaire, de l'adoption illégale dans sa globalité. C'est de pouvoir la considérer dans son entièreté et de pouvoir aussi considérer qu'elle a existé. Et ça, c'est une première chose aussi qu'on demande. Et alors, avec d'autres associations françaises, belges, mais internationales françaises, belges, américaines, australiennes, suisses, etc., on demande une reconnaissance des adoptions illégales à l'ONU, avec également... pour lorsque la charge de la preuve est apportée, c'est important de préciser parce qu'au niveau technique, c'est très pointilleux, de pouvoir effectivement avoir une reconnaissance d'un crime contre l'humanité pour ces adoptions illégales. Et c'est aussi en cela, et je remercie d'ailleurs monsieur Olivier De Fuvil qui est présent également pour son accompagnement et pour sa bienveillance dans cette écoute, cette thématique. C'est une émergence en fait. La thématique de l'adoption illégale n'est pas une chose facile, elle dérange beaucoup. Les travaux qui sont mis en place dans certains pays et dans d'autres qui ont déjà abouti, je prends l'exemple du travail de Back to the Roots en Suisse, du travail de Chile Worldwide Adoptees aux Pays-Bas et d'autres associations, Brésil Baby Affaires, etc. Ce sont toutes à l'initiative des collectifs, des associations que les choses bougent. Et donc, c'est à ce titre aussi que pour nous, c'était important de témoigner pour Racines Perdues. On remercie encore Child Identity Protection de nous avoir permis, de nous donner ce petit espace de parole pour pouvoir apporter notre éclaircissement. Parce que nous, dans le cadre du Guatemala, l'adoption illégale, on parle de plus de 70% d'adoptions irrégulières ou illégales, voire d'enlèvement d'enfants. Donc, je pense que les rapports sont assez clairs. J'ai eu la chance également de partager longuement avec les personnes qui sont mandatées par l'UNICEF pour l'adoption au Guatemala au sein même de Child Identity Protection. On a beaucoup échangé et c'est vrai que cette thématique, pour comprendre le futur et pour ne plus que ça arrive, il faut comprendre les erreurs du passé. Voilà, je vous remercie, je vous salue depuis le Guatemala et merci en tout cas pour votre intérêt. N'hésitez pas à nous contacter si vous en avez besoin. Merci beaucoup.
So I think we can all agree that was an excellent presentation of the work of Racines Perdues, especially with her efforts at the UN. And now it's talking about the UN. I have the pleasure to introduce to you Mal de Brouwer-Bucutier, who was also the UN Special Rapporteur on Sale and Sexual Exploitation in 2014 to 2020. We have the pleasure of working with her as our President of Child Identity Protection. And what I'd like to ask you, Maud, is based on your extensive work, including your work as a special rapporteur at the UN, can you explain why the restoration of identity is important in illegal adoptions?
Thank you very much, Mia. Thank you for asking me to provide some points of view, which I have acquired as UN Special Rapporteur, but perhaps also in my previous capacities, because my whole career I have dedicated to the issue. I mean, not my whole career, but most of my career was focusing on the rights of children. And this fits, this question which you've just raised is very much a question about children's rights. And so, as many other speakers this morning, I will refer to the Convention on the Rights of the Child as the primary legal text which should guide our discussions, because that convention states that the child has the right to know and be cared for his or her parents, and that he or she cannot be separated from them when it's in the child's best interest. When the child is deprived of his or her family environment, or when it is not in the best interest of the child to remain in that environment, he or she is entitled to special protection and assistance provided by the state. And in these cases, adoption is one possibility amongst several alternative child protection measures to provide a family environment to the child. So immediately, I think that sets the scene. It is a child protection measure. And therefore, it's very important perhaps to underline at this point that the principle, the best interest of the child is breached when the purpose of the adoption is to find a child for adoptive parents rather than a family for the child. And let me put it very clearly, international human rights norms and standards do not set a right to adopt a child or the right to be adopted. To subordinate the best interest of the child to the needs and wishes of prospective adoptive parents is to turn children into commodities and to prepare the ground for the lucrative business of sale of children and illegal adoptions. Yes, Mia, I looked at the question as when I was a UN Special Rapporteur on the sale and sexual exploitation of children. Of course, looking at it in particular in the light of the prohibition of sale under the optional protocol to the Convention on the Rights of the Child. It's actually quite striking that the optional protocol singles out illegal adoption as an example of illegal acts that leads to the sale of children by providing a number of, I would call, indicators, whereas that doesn't enter into such details for other practices that would equally meet the definition of sale of children. For example, Article 3.1a explicitly states that in the context of the sale of children, and I quote, improperly inducing consent as an intermediary for the adoption of a child in application of applicable international legal instruments on adoption must be criminalized both domestically and transnationally. The wording informed consent points to an enabling environment where the targets of illegal adoptions are parents, and in particular mothers, who are in acute situation of vulnerability. The other important element in this formulation is the reference to intermediaries, individuals or criminal networks who secure the adoption of a child through misrepresentation, bribery, or coercion, with financial gain as the primary objective. So you can see how clear we are here now in the remit of the concept of sale. So all adoptions which result from the commission of crimes such as the abduction, sale, and trafficking of children, and from illicit practices such as lack of proper informed consent by biological parents, improper financial gain by intermediaries and related corruption are illegal and must be prohibited, criminalized, and sanctioned as such by all member states. Investigations and prosecutions of illegal adoptions are, however, rare. Many of the acts involved are criminalized as minor offenses, for instance, a falsification of documents. But we're talking here about sale of children. That's a crime. It's not just a minor administrative oversight or offense. and the involvement of criminal structures, the reluctance to report, except for the birth parents, add to these difficulties. However, from the perspective of the rights of children who were illegally adopted, we need to look beyond criminalization of the offenders and ensure that state responses address their demands and their rights. And in doing so, we must be guided by the CRC. Listening to survivors, I often note a sense of lack of respect of their dignity and feelings of betrayal, not only by those who were actors in this process, but because of the continuing lack of recognition of their true identity and sense of deprivation and injustice by authorities and society as a whole. Given the importance of one's identity, international standards require that it only be changed when it is in the best interest of the child and that all elements related to his or her identity be preserved. Whenever a child is deprived of one of these elements, states have an obligation to restore the child's identity speedily. From the perspective of prevention, for instance, of trafficking children, it is also important to acknowledge the contribution by the 1993 Hague Convention, which requires competent authorities of the contracting states to ensure retention of information in their possession about the child's origins, especially relating to the mother and father's identity. It is true that this provision is a framework that doesn't provide a mandatory and unrestricted access. Yet at the same time this morning, we heard from Capucine that precisely the same institution has developed a lot of tools for prevention and addressing these illegal practices. And the toolkit in this respect, I think, is a very useful complementary tool for practitioners, but also for children themselves. When I reflect over decades of research, advocacy and activism, not in the least by victims of illegal inter-country adoptions, what strikes me most is the gap between acknowledgement, be it timid, of wrongdoing in the past and the redress afforded to the victims. The term wrongdoing is a euphemism for what is in reality a breach of human rights. Illegal adoptions violate multiple child rights norms and principles. Historically and still today, among those who favor inter-country adoptions at all costs and without adequate safeguards, ignore the damage caused by these illicit practices, including the loss of identity. The genesis of Article 8 of the Convention on the Rights of the Child is particularly telling in this respect. It was proposed by Argentina in the wake of the 1970s and 1980 dictatorship, during which time babies born to political opponents were removed from their birth parents after birth and their parents forcibly disappeared. This article was intended to prevent any similar situation from ever arising again and to help re-establish the identity of those children. When information about identity is incomplete or generated by illicit elements such as sale and illegal adoption, omitting or falsifying essential biodata, problems of a medical and psychosocial nature exacerbated by a sense of discrimination are likely to compound their sense of commodification and may have impact for a lifetime, as we heard so eloquently explained this morning by Daniel Pouras. Children's right to identity means more than just knowing who your parents are. Family relationship also include grandparents, siblings. It's also about relationship to a cultural or religious community, and it can have a lot of essential practical implications, determining right of access to public and health services and education. Both states of origin and receiving states must acknowledge the gravity of the situation and assume their responsibility, reminiscent of their obligations under Article 9 of the Convention of the Rights of the Child. States must ensure redress for victims through remedies that include reparation and support through adoptee search for origin. Redress is not just about compensation or apologies, however important. It must be about restoring what has been taken away from these children, and that is their fundamental right to identity. For that right to be restored, we need to ensure that states acknowledge their accountability as their duty to provide redress flows from that premise. Recognition of past wrongdoings by public instances are rare. Switzerland, however, did make this step in relation to adoption into Sri Lanka. Far too often, they depend on the willingness of those directly responsible, such as religious institutions, and do not lead to concrete action or accountability. Moreover, public inquiries to establish the truth and recognize the experiences of victims have been incomplete and failed to address concerns of all victims. As a result, in many cases, victims' demands for acknowledgement, apology, and redress are yet to be met. The setting up of commissions of inquiry and investigation in a number of countries, such as Belgium, the Netherlands, Switzerland, and soon France, mandated to look at the history and responsibility for historic illegal adoptions is to be commended as an important step in the right direction. But the process of collecting evidence and hearing testimonies of survivors should be handled with the utmost care. Lessons should be learned, and I can talk to you a little bit about what I can say in this respect in relation to what I found to have happened and still happening in Ireland.
That would be great, Maud, if you could explain to us, because that's a current reform that's happening in a country, and it would be good to see what lessons we can learn from the way they're working with the mother and baby homes and the adoptions that occurred in that situation.
Okay, I will be brief because I know we are short of time, but just to for your, I should remind you that, let's start. I paid a visit as special rapporteur to the country in 2018, and I dealt with a number of child protection issues currently not necessarily only concerning illegal adoption, but a lot of other issues. But nevertheless, during this visit, a central part of my inquiries and findings related to what happened to vulnerable women and children who were in mother and baby homes during the period 1922 to 1998. The survivors of whom I had an opportunity to meet. Those were children who were born in these homes, who were looking for the identity of their mothers, and vice versa. Women who had given birth in these institutions at a much later date, obviously, were still looking for their children. So, what the Irish government has done in 2015 is to create a commission of inquiry to look into basically all the institutional abuse in the mother and babies' homes, and that is obviously, in a way, for the purposes of our discussions today, and for the children who were illegally adopted, a too large a scope, because I mean it covered also other issues like forced labor, the causes of death of children who died in the institution, and illegal adoptions carried out in these institutions were only part of them. But nevertheless, so that made, in a way, the scope too large. On the other hand, it was the scope of the inquiry was too limited, because it had limited to a number of other baby and mother homes, but did not address adoptions which were carried out outside an institutional context, which were still in many respects fell short of the requirements which we would place under the Convention on the Rights of the Child. So the Commission's conclusions, the Commission adopted finally a report, this Commission of Inquiry, in October 2020, after a number of interim reports, and addressed indeed the procedures that were in place to obtain consent from mothers in respect of adoption, and whether these procedures were adequate for the purpose of ensuring such consent, whether they were full, free, and informed. In this respect, the Commission's conclusion was that there was a lack of evidence of forced adoption and abuse, despite these testimonies contradicting this, and that was particularly hurtful for the survivors. And obviously, the final report was strongly criticized by the survivors as being biased. It didn't heal the open wounds. Access to justice was not provided, no redress. And what was also totally missing from the conclusions, that there was a need for the religious orders to open their records. The suffering of the survivors and those concerned was exacerbated by the refusal to hand over a draft to those who provided testimonies, and refused access to their recordings. So all this eventually led to court cases, and in December last year, on the 17th of December, the Irish High Court declared the Commission of Investigation had treated survivors unlawfully. And I do not know at this stage what consequences will be drawn by the Irish authorities from this judicial decision. All options, I think, are still open. There could be a new report. There could be a report with international expertise. Definitely, the story is not over, and it's been drawn out far, far too long. And Mia, if I may just move very quickly now to the future, because precisely because of so many things which have gone wrong, the authorities have now introduced the Birth Information and Tracing Bill, which is designed to grant adopted people access to records about their birth and early life. Unfortunately, the survivors again expressed concern about not having been consulted before this draft bill has been tabled in Parliament. There are many, many issues which need to be clarified, and one of them relates to the scope of the legislation, who is concerned. It's a question of date of birth, place of birth, all sorts of discriminatory issues could arise. Important issues of compatibility with EU data protection rules, in particular the Article 15.4, as this should not lead to a situation in which most of the information, which is necessarily of a mixed character, is held back. And as to the modalities, there's concern about the mandatory information session in the event that the concerned parent is not willing to be contacted. In some reassurance is being sought that access does not mean that access means the file, the whole file, and nothing but the file. And I sincerely hope that review of the bill will meet the demands, legitimate demands of all these children and families. And let me conclude that today, by saying that today there's a generation of children adopted in the late 90s and 2000s, the peak of inter-country adoptions, who have become adults and are likely to embark upon the road in search of their origins, as we have heard already on many occasions today. In light of this, it is important for states to elaborate, whenever possible, adequate databases and DNA records, conducting awareness-raising campaigns to identify birth mothers who are searching for their children, establishing processes that are not complicated and expensive, and providing psychosocial support to triad members. The design and implementation of all measures and policies must respond to the needs of the victims, who must be consulted and empowered at all stages of the process. I'm sure there are good intentions in many countries confronted with similar issues. The question is how to get it right. There are lessons to be learned, hence the importance of sharing experiences, which will allow all other stakeholders to make the right choices. It is all about respecting the child's right embedded in the CRC. And let me then conclude by saying that, of course, CHIP stands ready to offer its support. Thank you very much.
Thanks, Maud. It's very, very clear to us that if states are going to do that first step of undoing an investigation, that they do it properly, because it can be even more exasperating if it's done so poorly without consultation, if they exclude some survivors, and that if survivors can't have access to all their records. So thank you for that, Maud. And now let me introduce you to Olivia De Fuvil. He's a Committee on Enforced Disappearance member and also a law professor in Paris. It's a real pleasure to have you with us today, Olivier. I think my first question for you is, because it's a new-ish topic for most of us working in intercountry adoptions, would you be able to explain to us what are enforced disappearances and what's the connection with intercountry adoption? Thank you.
Thank you very much. Thank you very much, Mia, and thank you for the invitation. I'm wondering whether you are seeing my presentation now. Yeah, you can see it? Okay.
Yes, yeah, we can see it.
Okay, thank you very much. Now the point is whether I'm able to move it. Yeah, okay, so Gisela is now.
Yes, I will be moving it for you.
Okay, thank you. So please, you can go on the first slide. To answer the first part of your question, that is about enforced disappearances, I would like to recall the definition of enforced disappearances in international law. And for this, I will refer to the International Convention that was adopted in 2006, the Convention for the Protection of All Persons from Enforced Disappearances, and more precisely, it's Article 2, which contains 4 elements. First, a person must have been arrested, detained, abducted, or submitted to any other forms of deprivation of liberty. Second, there is a refusal to acknowledge this deprivation of liberty or a concealment of the fate or whereabouts of the disappeared person. Third, the person is placed outside the protection of the law. And the fourth element in Article 2 is that the deprivation of liberty is attributable to the agents of the states or to persons or groups of persons acting with the authorization, support, or acquiescence of the state. On the state agency element, it is also important to note, however, that Article 3 makes an obligation for states to take appropriate measures to investigate acts defined in Article 2, which have been committed by persons or groups of persons acting without the authorization, support, or acquiescence of the state, and to bring those responsible to justice. Now, to answer the second part of your question, that is, what is the connection with ICA? I would like to take one example. That is the situation that prevailed in El Salvador in the 90s. I think Maud should switch off our sound, or you should switch it off for her, maybe.
Oh, I'm sorry.
If you are the animator. She's having a phone call with us.
No, she was having a call with me because I was asking her to turn off her mic. She's going to turn it off now.
Okay, thanks. So I wanted to take the example of Salvador and the situation that prevailed there in the 1980s. And to illustrate the situation, I would like to use the case, which was judged by the Inter-American Court of Human Rights. And this case is Contreras and others versus El Salvador. And then you can switch to the next slide. It concerns the enforced disappearance of 6 children in the context of the so-called counter-insurgency operations led by the armed force against the civilian population. And in its judgment dated 31st of August 2011, the court established that there was, at that time in El Salvador, and I quote, a systematic pattern of enforced disappearances of children. Such a conclusion coming out in particular of the huge work which was done by one association, which is called Pro Búsqueda, which received more than 1,000 complaints of children disappeared during the armed conflict. And I quote here the judgment, and I've put the quote on the slide so that you can follow more easily. This is paragraph 33 of the judgment. The disappearances form part of the counter-insurgency strategy developed by the state under the concept of destroying population groups associated with the guerrillas. Under that strategy, it found useful to abduct children in order to separate them from their enemy population and to educate them under the state's ideology at that time. The children were abducted during military operations after family members had been executed or forced to flee to save their lives, and they were frequently appropriated by military leaders who included them within their immediate families as their children. Some former soldiers testified that starting in 1982, they received orders to take any child found during an attack on enemy positions. In addition to the separation of children from their families as part of a counterinsurgency strategy, there were other reasons, including taking children to give them up for adoption. And then the judgment goes on by saying that according to the evidence brought forward, in particular by Probusqueda, the possible destination of the children after they had been separated from their families and disappeared can be broken up in 5 categories. And the first category mentioned is, I quote, and you can go to the next slide, adoption through a formal process within the judicial system, with the majority assigned to foreign families, mainly in the United States, France, and Italy. In the Contreras and others case, of the 6 children disappeared, only 1 had been found when the judgment was given. Gregoria Herminia Contreras was caught in the military during a large-scale attack. She was 4 years old at that time, and she was taken with her 2 siblings. The military told them their parents had been killed, and she was given for adoption to a soldier and his wife and was registered as their own daughter under the name of Gregoria de Jesus Molina, with a false date of birth. In this family, she was constantly abused. She was called a guerrilla and sexually abused by the man who called himself his father. Subsequently, she moved to Guatemala, where Probusqueda finally managed to trace her. After the judgment was adopted, 2 of the children of the 6 were found, including 1 that had been adopted by a family in the United States of America. In the judgment, the court recognized that these enforced disappearances against children violated their right to legal personality, life, integrity, and personal liberty. It also recognized the violation of the right to personal integrity to the detriment of the next of kin of the disappeared children. With regard to Gregoria Herminia in particular, the court found that she had also been a victim of enforced disappearance. The enforced disappearances when her identity was determined after Probusqueda found her and managed to have her meeting with her family. And the judgment found, and I quote paragraph 116, and this is the next slide, that abducting a child from a family and cultural environment, holding her illegally, registering her with a different name, changing her personal identification data with false information, as well as in certain cases, keeping her ignorant about all this, constitutes an aggravated violation of the prohibition of interference with an individual's privacy and family life, as well as the right to preserve name, identity, and family relationships as a means of personal identification. I have taken as an example the case of Salvador, but I could have taken the example of Guatemala. Colleen spoke about this. There is a case before the Inter-American Court, which also has a case of an issue with stolen children, the case of Las Dos Eres massacre. I could have also taken the example of Argentina, Uruguay, with the case of Germán versus Uruguay. From all these cases, what can be concluded is that a number of cases of illegal adoptions, including inter-country adoptions, have their origin in enforced disappearances. One could argue that the cases I have just mentioned occurred in a political or conflict context, and most of the illicit ICR are on the other hand, taking place in a more, let's say, common crime context with organized criminal organizations, trafficking, etc. I would personally argue that this is very difficult to make a clear-cut distinction. Take Spain, for instance, the practice of stolen babies, which has been uncovered in these last years in all its extent, and which started with the Franco regime. It started with clear political motivations, which are similar to what will happen later in some countries of Latin America, like El Salvador. But then it continued, and for the most became motivated by the lure of financial gain. But the pattern remained the same. Children were abducted, and then their whereabouts were concealed, and through the falsification of their identities, they were removed from the protection of the law, very often with at least the acquiescence of state authorities. So this is for the link, the definition of enforced disappearances and the link between enforced disappearances and inter-country adoption. Yeah.
Thanks for that, Olivia. If I could ask you a second question then about that is, now that we understand more or less what enforced disappearances are, what is the connection with inter-country adoption? And could you tell us about the legal framework applicable to enforced disappearances, in particular in relation to the right to identity?
Thank you very much. So I think we can go to the next slide. What I would like to do is first maybe to distinguish between general provisions that apply to all enforced disappearances and then specific provisions that are applicable to the case of children. As for the general provisions, I would like to mention three aspects. First, states have an obligation to open an investigation whenever there are reasonable doubts for believing that a person has been subjected to enforced disappearances, even if there has not been any formal complaint. This is what is written down here in Article 12, paragraph 2 of the Convention on Enforced Disappearances. I think this is quite an important feature in the context of ICA. What it means basically is that the fact that there are reasonable doubts for believing that some persons among a population of adopted children in one country might have been subjected to enforced disappearances is enough under the convention to trigger the obligation of the state to open an investigation. And by that, I mean a criminal investigation. In other words, if I take again the example of El Salvador or Guatemala, the fact that it has been recognized that a number of ICA find their origin in enforced disappearances, and this is now something which is well known, somehow it casts doubts on all the adoptions that occurred in that country in that period of time and make an obligation for states parties to open an investigation. And this includes not only the states of origins of the children, but also the states where the children were adopted in cases of ICA. The same goes with the search, which is separate somehow from the investigation, can be linked, but it's a separate obligation to search and localize disappeared children. According to Article 24, paragraph 4, and this is the next slide of the convention, the next slide, Article 24, paragraph 4 of the convention, the states parties have an obligation to take all appropriate measures. Well, that's enough. Sorry, I was mistaken in the paragraph. So I'm quoting the right one. Each state party shall take all appropriate measures to search for, locate, and release disappeared persons. And in the guiding principles that were adopted by the committee has made clear that where doubts arise about the occurrence of an involuntary disappearance, the search should nevertheless begin immediately. The second aspect I would like to mention that I think is of some relevance in the case of inter-country adoption is the definition of victims, which can be found at Article 24, paragraph 1. And this is the next slide. And this one, I hope I'm not mistaken. No, that's fine. Victim means the disappeared person and any individual who has suffered harm as a direct result of an enforced disappearance. And in case of ICA, this would include not only the adopted child, but also her or his biological family. And in some instances, we could discuss that in more details, his or her adoptive family. As stated in Article 24, victims have also a number of rights, including the right to know the truth regarding the circumstances of the enforced disappearance, the right to reparation, this is the paragraph that you could see before, and the right to form and participate freely in associations in order to try to find and locate the disappeared persons. The third aspect I wanted to mention in connection with the general provisions is the obligation of states to cooperate. Under Article 14, next slide, states have an obligation to afford one another the greatest measure of mutual assistance in connection with criminal proceedings. And under Article 15, which is the next slide, states should also cooperate with a view to assisting victims of enforced disappearance and in searching for, locating, and releasing disappeared persons, and in the event of death, in exhuming and identifying them and returning their remains. Note that this obligation of cooperation was included in the 1994 Inter-American Convention on Enforced Disappearance with a specific focus on minors. Now, to complete my response to your question, I would like to turn to the specific provision that has been included in the convention, specifically dedicated to children. And this is Article 25 of the convention. The first thing, and I would like to start by the end of the article, the last paragraph, if you could put the next slide, please, which is paragraph 5, and which provides that all the obligations under that article must be seen and must be read through the principle of the best interest of the child, which shall be a primary consideration. Now, what are these obligations? First, the states, and this is the next slide, this is paragraph 1, states have to prevent and punish as crimes under domestic laws 2 types of behavior. The first behavior, which should be a crime, is the wrongful removal of children. In French, the word used is soustraction, and in Spanish, I think it's even clearer. It's apropiación. The second crime should be the falsification, concealment, or destruction of document attesting the true identity of the children. This provision contemplates more specifically 3 circumstances where wrongful removal can occur. A, the child is subjected to enforced disappearance, his self or herself. B, her or his father, mother, or legal guardian is subjected to enforced disappearance. And C, the child is born during the captivity of a mother subjected to enforced disappearance, which was the case in the case of Germán, for instance. Second obligation states, and this is paragraph 2 and 3 in the next slide of Article 25, states have a specific obligation to search and locate for and also identify children, victims of wrongful removal and falsification of their identities, and to return them to their families of origin. And to this end, it is again provided that states parties should cooperate in the searching for identification and location of the children. And finally, the third main obligation, which is in paragraph 4, this is the next slide, No, sorry, previous one then. Okay, I missed this one. No matter, I will read it. Finally, third, given the need to protect the best interest of the child and the right to preserve or to have reestablished their identity, including their nationality, name, and family relations as recognized by law, states party, which recognize a system of adoption of or other forms of placement of children, shall have legal procedures in place to review the adoption or placement procedure and, where appropriate, to annul any adoption or placement of children that originated in an enforced disappearance. So there is an obligation to enact legislation in order to review adoption and, where appropriate, then taking into consideration the primary consideration of the best interest of the child, to annul any adoption or placement. I would like to conclude by saying that based on these various provisions and principles, and this is the next slide, both the UN Working Group on Enforced Disappearance and the committee have made a number of recommendations to states, including, and this is just a choice, inter alia, investigate cases of removal and or irregular adoption, ensure that disappeared children are returned to their families of origin if they have been victims of identity substitution, ensure that victims of identity substitution are able to exercise their right to recover their identity, create a DNA database that includes genetic samples for all cases of wrongful removal, enforced disappearance, or falsification of identity that have been reported, establish specific procedure for review and, where appropriate, for the annulment of adoption, placement, or guardianship that originated in an enforced disappearance, and for reestablishing the true identity of the children concerned with a retroactive effect. Provide victims with the support that they need to establish their identity and parentage, and clarify in full the circumstances in which they were adopted. And finally, guarantee a right to reparation to any person who has suffered direct harm as a result of an offense of enforced disappearance, irrespective of the date on which the act was committed, including when the harm originated in another state. Thank you very much for your attention.
Thank you for that excellent presentation, Olivier. Like I said, most of us have been working in intercountry adoption for, I haven't done decades, I'm not that old, but at least a decade, and we've never really understood how the Convention on Enforced Disappearances works, and it's a really important tool for addressing some of the intercountry adoptions that have occurred in the past. So we look forward to hearing from the committee and getting better clarification at what point an illicit adoption becomes an enforced disappearance. So thank you again, Olivier, and I'm sure we'll be in touch. And now it's my great pleasure to introduce you to everybody to Joelle Shekel from the Swiss Central Adoption Authority. She's the head of that. She's been working there for a long time. And Joelle, I'd like to ask you a very important question. We've heard people talking about your work in Sri Lanka. And I'd like to ask you about, can you explain to us a bit more what this work has entailed and what's it involved and where you're going with this work in Sri Lanka? Thanks, Joelle.
Thank you, Mia. Hello to everybody. I'm now trying to share my screen, get in full mode. It's all good? Okay, excellent. Thank you. So yeah, I've been in this area heading the Central Authority since 2014. Less than a decade. And all of it started for us in 2017. So I was still relatively new. And I think this kind of seminars or webinars we have today is extremely important because this matter generally is so complex. And we need to hear about experiences, how others have done, to learn from each other, to see what are all the options. Because when it all started, I was coming from my point of view of, head of Central Authority. We're in the daily task of seeing the adoption procedures, etc. And this was something quite far away. What happened in 30 years ago and how do we respond to it? from let's say what our daily task was. It is so much broader than just let's say the core of inter-country adoption, because it goes into dimensions of human rights and criminal aspects, etc., which have been so eloquently shown this morning. So therefore, what I'm showing today is just, the past few years. It's the start of a process. Because this is so complex, in order to bring any real change, it has to go through some legislative changes. And we all know that these are processes that can take quite long, especially in a federal state like Switzerland. So 2017, end of 2017 was when past scandals resurfaced for Switzerland. A TV reportage in the Netherlands, which was picked up by Swiss media because there was some connection to Switzerland. And the context was, as we heard a lot today, persons who were originally adopted from Sri Lanka as children in the 80s, 70s, 80s, 90s, and now becoming adult, searching for their biological family and finding out that there's a whole huge story behind this, that in the 80s, there were already in the media in Switzerland, wide coverage about possible child trafficking from Sri Lanka. There were also at the time already questions from politicians, reports of baby farms, acting mothers, and all kinds of illicit practices. So immediately, of course, the journalists came to us and asked, well, did you know that? What did you know at the time? How did the authorities react? First of all, we were, well, this was 30, 40 years ago. We have no idea that we didn't even exist as an authority back then, etc., etc. We were only created in 2003 when Switzerland ratified the Hague Convention. So it became relatively quickly clear that this was turning into something bigger. And in March of 2018, we received the official mandate from our parliament to present a report on the matter. So the aim, first stage, know your facts. The first stage, historical research, it was also clear that this research had to be done in a way that ensured both quality, integrity of it. So the mandate was given to the Zurich University of Applied Sciences. And in order to accompany or monitor the report and their work, an advisory group was set up, which included representatives from the state, but also from Back to Roots, this Swiss NGO from and for and with people adopted from Sri Lanka in Switzerland. The report from the Zurich University was published then in January 2020, more than 250 pages, quite detailed. And based on that, a few months later, in December 2020, the Swiss government made its official report to respond to the Parliament's original mandate from 2018. So the second phase, once you have the historical facts, is facing these, right? So based on this, on the findings of the report, the Swiss government acknowledged the past wrongdoings of the Swiss authorities and expressed its regrets towards the adoptees and their families. Facing the past is good, but it's of course not enough. You need to look ahead and get into action. So the report not only looked at the past, but also offered an analysis of the support offered nowadays by Swiss authorities for adoptees in search of their origins. And in the wake of this, a working group was set up that included adoptees as well. It's still ongoing, the work to discuss and propose improvements to the system. And lastly, the report also included an initial analysis of the actual system of inter-country adoption in Switzerland. And this will now also be further examined by an experts group, which will then give recommendations. So all of this So a little bit frustrating that it all takes time, but at the same time, if you want to do it properly, it's a little bit difficult to do it differently. And finally, the other part, which is of course extremely important, is what are we concretely now doing in order to help adoptees generally, but especially the ones from Sri Lanka, because obviously that's where the attention was. So the absolute right for adoptees to know the identity of their birth parents has been formally included in Swiss legislation since 2003. And there was quite a big change enacted in early 2018. So that was actually all done prior to this whole story, but that also impacted and still impacts the way we're doing things. So each of our 26 cantons has designated an information and counseling service that has to support the adoptees, both in Switzerland and abroad. We also agreed on a collaboration protocol with the Central Authority of Sri Lanka, because both them and us, we are Central Authority under the Hague Convention, which didn't exist at the time and obviously wasn't applicable. So you have to also find an agreement to actually cooperate, even though all these cases were dating from a time when our authority didn't exist and we were doing this not under the convention. And the last part, and that is starting this year, is a pilot project starting with the NGO Back to Roots to help finance additional support for Swiss adoptees from Sri Lanka. So that would be for my first part.
Okay, thanks, Joelle. That's really great that you are having this concrete help for adoptees. I have a second question for you that I was interested in, but what would be your key lessons that you have to share with us in terms of restoration of the child's right to identity, which would also be helpful for other states that are going to face or are facing the same issues as you?
So when preparing the question, I had to fight hard not to put all the lessons, because, I mean, first of all, it's still a work in progress, but there are so many lessons and so many things, of course, I would have done, or we would have done differently, but at the same time, others that we're happy with it this way. And here I tried to concentrate on what I see is in direct link with the restoration of the child's right to identity. So it's not a lesson of the whole process generally. The first hard truth, but that we have to just admit, it's search for origins for historical cases is very hard. Generally, it is hard, and it's hard for many reasons. There was no focus on this aspect in the past. I mean, adoption secrecy was very high. There was no talk in the 80s. I mean, we're talking pre-Children's Rights Convention time, even for most cases. So we have to really learn the lessons for the future. This has been said earlier this morning as well. What do we put nowadays in the children's files? What kind of information are we sure that we put in there? Also, how do we prepare the prospective adoptive parents, et cetera, et cetera. It is also hard because it would be essential to have both national and international strong legislative framework and international cooperation, but we're not at all on the same level. Some countries have well set up authorities and competencies. Others put still a very high importance on the protecting the secrecy and the birth parents' rights, etc. And also, as I said, it's not just about finding the parents, that we need a comprehensive approach when it comes to these historical cases, especially when there is a case of illicit practice. So when there is some fraud, like the many examples that were given, linked directly to the child's identity, the search, is almost impossible. How do you start? Where do you start? Lots of questions now on, are the DNA databases the only way? If they are, how do you set that up from a data protection perspective? And you can't just do, Switzerland on its own. It's something that definitely would need to be done in the multilateral level, and we're still quite far away from that. But at least we're advancing in the discussions. Financial implications, the money as the heart of it, who should pay? I mean, that is still an open question in Switzerland, in many other countries. You can have great programs and everything, but at the end, you need the funds, and if you need to have money, that means you need to have political implication and support for all of this. So it's not something you can just quickly do as a central authority on your side. It needs something bigger. Other aspects linked to identity, which are much bigger than our role as central authority. Is the adoption even valid? How do you invalidate it if you want to? How do you change your name? How do you get your old nationality back, etc.? I mean, it's really big. And our systems generally are just not tailored for this much larger picture of all the different aspects that are linked to this. And the very last point I would like to make as a key lesson, and that is valid for anything we do in this area, and that has been said already this morning, is how crucial it is to involve adoptees in the process. Because, and the point I just made before was the importance of facilitating access to authorities and official procedures. It is not for us to judge, working from the authorities, the feelings that I've heard expressed by some or even many adoptees say how difficult is this to go to authorities, because the whole problem in the past was linked to authorities not doing their job properly. And of course, me, objectively, I'm going to say, well, but it wasn't me, and it was different, and you can't put it all in the same bag. But that is not a discussion to have. We have to just accept absolutely and hear the issue of adoptees going to authorities to do this whole process, and ensuring to see how can we grant this access to authorities to the right procedure. And I'd like to finish by wanting to really underline the extraordinary determination and courage of Back to Roots and its members in Switzerland. They really shared very deeply personal stories with us and with the wide public. It must take so much courage to do that. They have been and still are really invaluable partners for us. And hearing and understanding the needs, the very diverse needs, as had been said before, every person has a different story. It's crucial, it's essential, and it's our job to also help facilitate that, because we can't just wait for them to get together and have a platform. We need to also facilitate that. So thank you so much.
Thanks, Joelle. Really, the reason why we invited Switzerland is because for us, it is a receiving state that has this promising practice of working closely with your adoptees. I hope that it will expand to work with other countries of origin at one point. That's the next challenge. But what's encouraging is that you mentioned all these challenges, but despite these challenges, you're moving forward. You're having, you're providing some resources to the adoptees. And I think that that's what is really helpful, is that there is this political will. So thank you, Joelle. Now it's my pleasure to introduce State of Origin, the Colombian Central Adoption Authority. I think that they also are doing an excellent job in terms of helping adoptees access their origins, in terms of what they've put in place. If I'm not mistaken, it is Erica Joanna Martinez Perez that works in the Central Adoption Authority that will be presenting today, because unfortunately the Deputy Director is not able to join us. So Erica, would you be able to explain to us the work that your Central Adoption Authority is doing in search for origins?
Gisela, necesito que me ayudes un poquito, porfa. Es que...
Por supuesto, dígame.
Gracias, perdimos la conexión con Erika, me está escribiendo por WhatsApp.
Ok.
Me dice que está sin internet. No sé si le damos unos segunditos porque está reiniciando el sistema y veo que está como tratando de ingresar.
Vale, perfecto. He said that they lost connection, like Erika lost connection. She's trying to reconnect, so Shall we give them like
Yeah.
a couple of seconds? Or
No, what I suggest is that we have a very short break now for 3 minutes, and then we'll start again in 3 minutes time, so that we've had our break now. So in terms of this session, thank you for the panelists, really helpful and encouraging insights in terms of the high bar that states have in terms of restoring children's identities. What I think is great is that the political will is here, that it exists, and we also now have, we can have a look at the Convention on Enforced Disappearances that we haven't really used as much as we probably should have, although of course with that caveat that it's not going to be applicable to every single intercountry adoption. So let's start then again at 2:20. I said 3 minutes, I've taken 2 minutes away now, but yeah, let's start again at 2:20, and hopefully we can work out with the Colombian Central Adoption Authority to be connected on time. Thank you, and have a good little break, but very short. Okay, so that was a very short break, but I think that the presentations have been of such a high quality that everybody's keen to continue with the presentations. I think what we will do is we'll get the Colombian Central Adoption Authority to present in this next session when they're able to connect, which works as well, because in terms of the future of intercountry adoption, countries of origin will have to set up systems like Colombia. So it works. That's how we'll do it. But before that, let me introduce everybody to Lynelle Long, who doesn't need any introductions. But as she will be talking to us now in this next session on the future of intercountry adoptions, I think it's very important. She has a wide network. She has vast experience. She's well respected intercountry adoptee. And so Lynelle, if I could ask you this question, you've built up this massive, large, worldwide network of adult intercountry adoptees. You've been a witness to the massive changes in your community. How do you see the future of intercountry adoption?
Now, you did tell me, Mia, that I was allowed to be honest and truthful, right? So hopefully that's still the case.
Absolutely. And I should say thank you, Lynelle, because let me calculate the time. Is it like...
Oh, it's 20 past midnight. Yeah,
oh, yeah.
That's okay.
It's okay. It's Friday night. It's Friday night. It brings you back to your youth.
At least I don't need to, wake up and be too sane tomorrow.
Okay, thanks, Lynelle. Absolutely. Yeah. Truth and transparency is what we want in this webinar.
Good. So... okay, I just speak for myself, but in my humble perspective, I really believe the future of intercountry adoption is pretty much slowly coming to its death. I am personally happy about this, as are a vast number of intercountry adoptees around the world. I recognise that not all adoptees agree with that, though, and that they don't want to see the end of intercountry adoption. And the argument that they pose would be that, we've gained and benefited so much, and why would we stop others from having the same? I guess, my point of view is that I believe we're actively robbing countries of their most valuable resource, their children, when we take away, what is their most valuable resource. So when we do that, and when we take advantage with our privilege and our resources to gain from other people's vulnerabilities, I just think there's something ethically wrong with that. We need to do better. We need to do what's ethically right, especially when we know in hindsight, and, we've just heard so many people talk about, all the history and what we know now. We know better that, the random positive outcomes cannot in any way justify the huge amounts of trauma that have been inflicted on so many people. We've seen some countries in Europe starting to take responsibility. I love what Switzerland's doing by independently investigating the history of intercountry adoption and coming to terms with the wrongs that have been done to so many. COVID has also created a natural dampener to the trade in children via intercountry adoption. But also, I want to really talk about, I guess, the efforts of intercountry adoptees and our allies that has been building over the past couple of decades to really culminate into this worldwide recognition that intercountry adoption as a social experiment has not been as successful as many had hoped. We are just inundated with so many problems because of the historic practices. And if I were to ask myself to think about what the future of intercountry adoption looks like, I can't lie, I can't pretend to uphold the fantasy that so many have with adoption. From a lived experience, too many of us have actually struggled and suffered lifelong consequences of being robbed of our origins, our kin, our country, our culture, our language. And it's time we take an honest and critical look at what it actually truly does. It is the only alternative care option that proactively severs our right to identity and our family relations. So except in these few cases of countries like Vietnam, Belgium or France who actually allow simple adoption to exist, the rest of the world uses plenary adoption. And in reality, it is extremely rare to ever have a simple intercountry adoption. So I can only gauge the future and what it brings from where we have shifted from and moved in the past, 24 years that I've been actively involved. And I have seen massive changes that my intercountry adoptee community has undergone. We've gone from being completely isolated to each other to now completely, massively connected, from being in the fog and not even understanding what's even happened to us, to being totally awakened to the reality of the structures, the infrastructure that's created our very lives, from relying on dodgy fabricated paperwork to completely embracing DNA technology because it doesn't lie. Well, sometimes it does if you use dodgy DNA companies, but yeah. But also too, from not wanting to engage in politics. I remember in my early decade of being involved, I just did not even want to get involved in the political aspects of intercountry adoption. Whereas now I'm fully engaged, I'm seeking engagement with governments and authorities. We've moved from not understanding our rights to now actually finding pathways to uphold our rights through laws and conventions, demanding justice, demanding reparation. This is what excites me the most is actually seeing the many adoptees who I know who are finding pathways and wanting doing their best to demand justice. And we're inspired by the success of pioneers who go before us. My very close friend, Patrick Nordovan, is one who I admire because he has fought the lack of, having a legal pathway there clear and open, but he's actually studied the laws, faced the courts, and he's created a legal pathway in the Netherlands to demand justice and demand the truth, which is our right to identity. We need more of this to happen en masse, and I'm really excited to see that there are so many adoptees around the world starting to really take this up and find a way. And then what we're seeing right now too, especially in the past few years, is that some governments are starting to recognise that actually they need to do a better job at protecting themselves. We always see movement and change when people suddenly realise there's a vested interest. Because, governments are recognising that they're now actively participating in an activity and a system that's actively robbed us of our right to identity, our right to origins, our right to family. Once more governments realise the risk that they bear, I believe we'll start to see intercountry adoption as it's practiced today become almost non-existent because it's just too risky, too costly. Intercountry adoption has always been about money. Who has it, who doesn't have it, who doesn't want to lose it, who can't afford to take risks. Well, while the risk was historically gauged as low in the past, governments and authorities have supported the demand for children via intercountry adoption, but now that tide on that sentiment has turned and there's no going back. I do believe one day we'll look back historically on this huge social experiment that we call intercountry adoption in order to hopefully eventually be acknowledged on a global scale that it was never in our best interest to be removed from our country, culture and kin. All it does is actually add to our traumas when in fact we're supposed to be helped. So hand in hand with this, I'm excited to see some governments starting to recognise our adoptee needs and rights. In Australia, like with a couple of other countries that I've heard now, we've been some of the, few countries to give funded free mental health counselling service and free search and reunion services. Both of those, I say, should be an absolute, minimum in all post-adoption services in every adopting and sending countries. Some countries are currently talking to me about, our Australian model and how we've done things. And I know other countries are already providing or either looking at one or both of those services. But while I celebrate the shifts in what some progressive countries are doing, I want to just remind us, let's not forget the families of loss who still barely have any voice at this table, who barely have any rights and usually still have no access to counselling or searching services. I hope in the future that we'll start to see that change. You know, the voices of our families of origin are still largely unheard, ignored and denied, and we have to change that. So I hope to see that intercountry adoption will only become a last resort option, as was originally intended under the UNCRC. Thanks.
Thanks, Lynelle. Extremely powerful as always. If I have one question for you, if there was nothing preventing change, what would your utopia of intercountry adoption look like?
I love utopias. Well, what I hope for the future is possibly just a utopia at the moment, but sometimes when we speak our words out loud, our words can find an energy with others who share the same desire, who start to understand. And that can start the small wave of thoughts, become an activity, that activity becomes a movement that has ripple effects that eventually turn and flow into hopefully a tsunami. So I know that there are so many in our adoptee community who are working hard for these changes to happen. And each of our efforts can just be, that can seem so small in isolation, but together en masse, we will eventually affect that change that we're working towards. That's what I try and do every day. My utopia, I would love to see an end to all intercountry adoption as it's currently practiced today. You know, obliterate it, or as a minimum, redesign the Hague Convention to ensure that our right to identity, culture and family relations is actually preserved, and ensure in particular that there legislation exists that actually supports our rights as adoptees and for biological families. These two parts are just absolutely missing from what's there today. When we do this, we need to also remember, you know, a huge point is remove money from being any incentive for profit and gain out of this equation. You know, I can't speak more highly about that need, and why is it so hard for governments and authorities to actually eliminate money from the equation. We also need to, as I've talked about before, remove plenary adoption. That is an ultimate, you know, just abhorrence to our right to identity. It should be just killed and aborted by now, but for some reason, countries and governments and legislation, it just seems so hard to change it, but why? We need to ensure that adoptees have the right to annul their adoption without any cost. You know, currently what I'm seeing here in Australia alone, you know, just the cost, $1,500 for an adoptee to have to try and go through the process to annul their adoption. How ridiculous. We never had a say. Why do we have to pay to actually try and have a say when we want to annul their adoption? We also need to ensure that generational rights to adoptee records are actually considered. That is, you know, our children, my children. If I chose as an adoptee to never look for my adoption or birth records, when I die, my children don't have a right to look for, to access them. Why is that? Because we've never thought of adoption from a long-term, lifelong, intergenerational issue. We need to change the way we look at adoption and recognise these lifelong intergenerational issues. You know, some of us have already talked about improving pre and post adoption supports. And as I've said before, it should be absolutely mandatory that this be free, trauma-informed, lifelong, comprehensively, but most importantly, in the design of it, to actively consult with lived experience expertise. Together with that, it's so important that we have mandatory education for support professionals so that they understand basics like the heightened risk of suicide amongst intercountry adoptees, the trauma that we face, the inherent racism, the identity conflicts. There are just so many issues that we live that we need trained and informed support. Adoption is not just an adoptive family, a birth family, and adoptee. We need a whole community that supports if you're going to continue to do this type of practice. We need to, you know, stop adoptions that are private and expatriate. I mean, let's just be honest and admit that so many of our historic illegal adoptions are actually stemming from those practices, you know, and yet we still haven't stopped them. And then next we need is a legal centre of expertise that's basically created and funded to help victims, the adoptees, the birth families, to hold agencies and countries accountable where these countries do not provide help and support that is so necessary for victims. We need an independent body to monitor and punish Hague signatory countries who actually don't uphold their responsibilities. For countries like America, where adoptees are proactively being deported, that's just unbelievable. And so many people don't even understand that it even happens. for when there are also cases like abuse, murder of a child by adoptive family. You know, our community cries out that there needs to be so much more accountability for those who are responsible for placing us into families and countries where our experience ends up being more traumatic than where we even came from. We also need an international organisation that's set up to empower and help support biological families who are searching for their children. I meet so many who write to me who just are so disempowered, have nowhere to turn because their countries and governments just, you know, don't care. And before we even talk about adoption as a solution for children, I believe we need to ensure that the focus and the funds prioritise family preservation. If this actually happened, we wouldn't even need inter-country adoption. We need to help our countries implement better social welfare alternatives like foster care, guardianship, group homes, simple adoption, and fundamentally to make sure that these are really, really well resourced. So regardless of whether or not we have inter-country adoption or not, we need to deal with the past for those who are impacted and have those historic investigations, learn from the past, ensure restorative justice for victims, ensure compensation. Only then should we ever move forward and consider how we do adoption in the future. And from this too, a really important point I want to make is to make sure that we cross-pollinate our learnings into other family formation methods, such as surrogacy, huge issue that's arising now. And we need to apply the lessons we've learnt to prevent further commodification of children and robbing them of their identities, because they are going to end up living almost identical lives to what a whole cohort of people like me as inter-country adoptees have lived. These are the things I spend my life working on, creating, joining into the groundswell of people, all pushing for these much needed changes. And for this to happen, we really need to challenge governments and stakeholders around the world to ask the tough question, is inter-country adoption the ethically and morally right thing to do when we know that other solutions can exist for children that better respect our right to identity, culture, and family relations? So sadly, my utopia doesn't exist right now. And I can only conclude that until we have a system that upholds our adoptee rights, I don't believe we should be conducting inter-country adoption in its current form. It is not in our best interest to add on layers of trauma that can be prevented when we know better. Yes, there will always be children who need support and alternatives, but we can't keep repeating the mistakes of the past, turning a blind eye to what we are doing to so many en masse. We must do better. We must challenge ourselves to be honest, truthful, listen to the voices of those who are impacted most, and heed the lessons that we can learn. Thanks very much for having me here.
Thanks, Lynelle. I do hope that we continue to move towards your utopia and that we will get to your utopia sooner rather than later with many of your recommendations and your vision. It's a great vision, and if we don't have a vision, we won't go anywhere. So you've set the benchmark for us. What I suggest now, and thank you again, have a good weekend. And I don't know if you're staying on because it's past midnight, but we have Laura now, Mora Martinez Mora, to share her presentation, and then we can have Colombia, because I think that it makes sense that we have the states of origin and the receiving state Australia speak after Laura. Thank you, Laura. Laura is a secretary at the Hague Conference on Private International Law. She has been working in inter-country adoptions, I think, for 2 decades, if not very close to 2 decades. She will speak about the 1993 Hague Convention in the future. And Laura, if I can ask you one question first. Is the 1993 Hague Adoption Convention still fit for purpose, taking into account the low numbers of inter-country adoptions and the children that may need to be adopted internationally?
Thank you very much, Mia, and thank you for the invitation to take part in this webinar. I think the standards are really up, and it was very interesting to listen and to hear and to see how we can move forward. So if you allow me, in order to respond to your question, I will try to share my screen. Please.
If it doesn't work, Laura, you can send it to Gisela. Huh?
No, it's fine.
It's fine. Okay.
I think so.
Yeah, it's fine. We can see it.
Okay. Doesn't allow me. Okay, I think here we are. Sorry for the delay. Okay, so it's difficult to see after everything that we have listened. Okay, what can the 93 Hague intercountry adoption do in the future, and how we can move forward? As you were saying, is it still fit for purpose? What we have to know? I think the first reflection that I would like to make is that it has already been seen, is that in order to speak about the future, at least in intercountry adoption, we have to take very much into consideration the present and the past, because this future is based on those two, especially with all the different abuses, all the different problems that there has been, and that there are still been in some cases. So it's very important that if we look to the future, we take into consideration, and as it was said before, we learn from the past. I think if not, it's difficult to imagine a future on intercountry adoption, and as well a future for the convention. Then you all know these statistics. So going really sharply down since when we had the peak in 2004. So for 2020, we had approximately 3,700 intercountry adoptions. It may be even less because some of these figures also include some countries that count intercountry adoption in fiscal year. So it will include some adoptions that were done at the end of 2019, so before the COVID. But in any case, numbers are going down. This is something that we know very clearly. And we also have to see who are the children that are in need of intercountry adoption or that are being adopted currently through intercountry adoption. And as you many know, you already know, many of those children have special needs. So if there is future for intercountry adoption, we have to target it to that and take into consideration that. And as well, there's also in many cases, we have intra-family adoptions or adoptions by step parents. All these adoptions should also be done under the convention. So that's something that we have to take into consideration. When we think about the convention, as we saw, and it was said as well at the beginning, it was drafted just at the same time or just after the CRC. And it's very important because this convention, the idea was to protect children and of course to cooperate. To cooperate doesn't mean to do more or less, but if you do it, to do it then properly and don't do it in a private way. Something that has also been said, that private adoptions and independent adoptions are not in line with the convention. Of course, the convention is not the solution to everything. The convention presents you, as you all know, the legal framework, and this is the basis. But of course, as has been said afterwards, the importance, and if it works properly, it will all depend on how is it implemented. And in order to implement it properly, and in this case, we are now, as you know, with 104 states parties. In order to do that, you need political will to do it properly. You need resources. You need people who are trained. You need an ethical behavior, and you need to increase guarantees. So it's really important to do all of that in order to be able to do intercountry adoptions properly. There is also a difficult balance that we have to struggle and that we see. And is that the intercountry adoption has to be based on a child protection system. If the child protection system works properly, there's no need of intercountry adoption. If the child protection system is too weak, maybe we could see, yes, there are some children that may benefit for intercountry adoption, but the problem is that it's very difficult to do intercountry adoptions with safeguards. So how can you ensure those safeguards? So this is a very difficult issue that hasn't really been resolved. And when we speak about the inter-country adoption, of course, we have to always put in the balance two different things. So on the one side, there is a need, and not for all child protection measures, to take a decision on a timely manner. So we need to give an answer, but in a time we have to respect the times of the children. But this doesn't mean that you have to just overpass the guarantees. They are even more important. So the guarantees and safeguards need to be there. So we cannot say do it too quickly and then you have no guarantees and then we have the problems of the past. Or you don't take a decision and then maybe you have a system that is too bureaucratic or difficult to implement. And then what happens is that the children may be raised in institutions. And we know that being raised in an institution is not good for children either. So we need to do more regarding safeguards, procedures, and control. We have learned that what has been done in the past is not enough. And as well, something that we have been learning with COVID is the use of new technologies. How do we include those in the inter-country adoption procedure and the whole child protection system? They can be helpful, they can help maybe to have more training, to have more people involved, but we also have to take into consideration the children. Is it the best way to communicate with them? Which kind of safeguards? Can you really make good contact with them? So we have on the one side to take into account the advances and how it can be helped, but on the other side as well, we need to see what is best and not just take yes and no, but informed decision and with faith. And there may be the last thing for this question is, well, it has been said before very clearly, and we know it. The source of the biggest problems in inter-country adoption has been money. At the end of the day, in many cases in the past, at the end, the children were adopted because of money. And this is an issue, as we discussed with Nigel and in the ACCH working group on preventing and addressing illicit practices. Why should the prospective adoptive parents and adoptive families be financing the child protection system and adoption as such? It really makes it very difficult. And it's really a source of problems. And therefore we need to, one, prevent illicit practices, and then if regrettably they still occur, you need really to address them. So 93 Hague Convention tries to give some guidelines, but more is needed because in some of the articles still a convention is very general, and therefore it is to states to really raise the standards.
Thanks, Laura, for that. I think it's a very clear picture that you have in terms of the role of the 1993 Hague Convention. Can you explain to us what the convention says regarding to access to origins? Because I think that that's a really important part in terms of the future of inter-country adoptions, because clearly it's a real need that adoptees have. And yeah, I'll stop there.
Yeah, I fully agree with you. So we have the first obligation of the convention, and this is key. The first one is to collect information and to preserve it. So, and this is clear in two different articles in the convention. So if you don't collect it and preserve it, then nothing can be done. So that's the first one. And then we have in Article 32, the idea that was put there that the child or his or her representative has access to such information. And it has to be done under appropriate guidance. So that's very important, that there is counseling, there is work being done, and there is support in order to accompany all the different parts of the adoption. And then, yes, we did have, when the convention was drafted, was saying insofar as permitted by the law of that state. So that's when you draft an international treaty, sometimes you need this last part of some of the articles in order to have some states that if not, they may not be able to join. But the main idea of this article, that's the key, that should be the exception, the last part, but the main idea is that there is access to information. And it's a recognition that it is very important to have it. We have heard it this morning. And, yeah, we need to have this access to see how to accompany, to see, is thinking about the child, the adoptee is about not just keeping the information for a specific number of years, but for forever, in order to have this, the possibility to access to it, properly preserve it. And as well, something that we haven't explored yet, but it happens quite very often, is as well birth families looking for. So how do we hear their voices? How do we accompany them? Is there a system where they can also say, yes, we are looking for? So some countries have started with that, but there is much more that needs to be done. And maybe finally is to say that in matters of parentage or in matters of adoption, we cannot just think when the child is a baby, because they say, oh, well, the best thing is that he or she has a family. We have to think about this person through all his or her life. And this is very important, because you need, when you take a decision, you have to think what this person would think in 20, 30, 40 years, how he would feel. And it's not just taking into account what happens in that moment, but as well the rest. And I think that should guide any measure that we are taking. So I think for the future in general, we have first, because the number is very low, but this of intercountry adoptions now is really low, but there's still a lot to do on post-adoption. And this is this is the second key topic that will be discussed at the Special Commission in July this year, if COVID allows. And then if we do intercountry adoptions, which are going to be really a small number, to ensure that they are done with all the safeguards and guarantees. If not, it's, yeah, and this includes, of course, right to identity, access to origin, and everything. And if not, one we should really seriously think if there is a need and if it's good to do intercountry adoptions that are not done with all the safeguards and guarantees. Thank you very much.
Thank you, Laura. I think that that's a really powerful message to just to end the presentation here. Terms of, if we can't do it properly, then let's not do it. And so I think now I'd like to introduce us to our Colombian Central Adoption Authority. I can see that Erica Joana Martinez Perez is with us, which actually dovetails nicely with the presentation of Laura, because she will be talking about the work of the state of origin in search for origins and what they've set up. And for us, is this very good, promising practice. So, Erica, I give you the floor.
Oh, thank you, Mia. And I'm so sorry. I apologize because of the technology difficulties, but I'm here right now. And I think, maybe this is the moment, because my presentation is really, related to the information that Laura was sharing with us. So I think we are in the same way right now. And thank you for the invitation. And we want to share with you about the family origin search procedure in Colombia. And I want to start saying that for us, it's really important the right of the adoptees to know about their origins. So that's why in Colombia, we designed this procedure. And of course, when we talk about the adoptees, we talk too about the biological families and about the adoptive families. So we have in here 3 services available for the adoptive triad. Javiita, me ayudas, por favor. That are part of this origin search procedure. The first one service, Javiita, is the copy of the care file. Through this service, the adult adoptee who requests to the ICBF may have access to a digital copy of the documentation relating to their process of protection that includes includes the right to restoration and adoption part. And, you know, this will enable them to find the continuity between their life story of origin and their current life. Because, you know, the adoption is not just a moment when they are a child, like Laura says. The adoption is for the whole life. So this is just a part of the adoption. What about the underage adoptees? Only their parents, their adoptive parents, as their legal representatives, may submit a request to the ICBF. Now I want to share with you something like the step-by-step of this service. The first phase is the submission of the care file to the applicant. The first step in here is the professional lasting of the research, search, retrieval from archives, and digitization of the adoption file. We have the files in different points in the country. We have in Colombia 33 regionals, so it depends. So where the adoption was carried out. The second step is the review, analyze, and summary of the information gathered from the file. And in that moment, the professional will offer a video call to the adoptee in order to present him or her with the digital file and to review it with her or him, because it's really important for them to have this support, not to be alone, you know, in the process to be in touch with their origins. The next step is, or something that is important to consider, is that the information in the whole process is sensitive, the whole information. So we suggest to the adoptee, you know, look for psychosocial support in their country of residence, because we are in the other side of the earth, you know. So it's really good for them to try to access to that the ICBF professional undertake interdisciplinary activities with the adoptive psychologist or therapist before to send to the adoptee the full file. The next phase of the service, Javito, is really important too. Javito? Javi.
No me corresponde un segundo.
Okay, I'm so sorry. Oh, okay, we have the new one, the new slide. Okay, this part is really important, you know, because sometimes it's really hard to find the files. Why? Because before 1975, the adoption process were not in charge of the ICBF. And between 1975 and 1989, there was not a law about the reserve of the files. So for those cases, we have this step that is the reconstruction of the care file. So if we cannot find, if the file can be found in the ICBF archives, based on the information provided by the adoptee, we start a search for documents relating to this adoption process, and we work with the external bodies that were involved in the adoption. You know, it depends on the year. We work with the National Office of Civil Registry, the courts, etc. The second step in this case is, again, a review, analyze, and summary of the information found in this process. And then we offer to the adoptee a video call, of course, to present him or her the digital file and to review with the adoptee the information, because, again, it's important to give them the context. Okay, The second service that we have available for our adoptees is the search for the family of origin. The aim is undertake an active search for the origins family, and we put our view initially on the parents by determining the feasibility or not of finding them and their willingness to proceed with a reunion with the adoptee. If we have enough information available in the file, we can move forward, trying to find other significant relatives like the grandmother, grandfather, uncles, aunts, who were involved in the child's care and are mentioned in the file. Of course, we offer psychosocial support to the adoptee triad through the process in order to facilitate, their understanding of the search potential outcomes that could be many. So, of course, we like to work in a collaborative way with our colleagues, central authorities, bodies, adoption bodies authorized and everything. So, other thing important here is the adoptee may request a search for the biological siblings who remained with the origin family or in the protection system. But something in here is very important to highlight, and is about those siblings who were adopted too. What happened with them? Their file is unreserved, so we cannot move just like easily in those cases if this sibling who was adopted to doesn't ask to us the same process, to be in touch with their biological family. So that's important for our adoptees to know. What about the underage adoptees? So we moved in this process for search for the family of origin only if there is a concept from a professional in psychological or physical health, who is saying to us that this is totally necessary for, a therapeutic process, and it will not be, counterproductive for the adoptee. In this service, the first part is the same, like in the service of the copy of the care file. So the file is sent under the same conditions. Then, during the review and analysis of the care file, we put particular focus on the relatives identification data, because that's the base that make us or not possible, to move forward with the search. Then we moved based on the information that we have from the care file, consulting through government and some private bodies to try to get potential contact details about the biological relatives. Then, when we have this information, about the contact, the possible contact for the biological family, Javi, ¿me regalas la siguiente, por favor? We will try to contact the biological family. So, if we have a phone number, of course, the professional initiates the contact by phone, in order to verify the identity of the sought person. Because, you can find many people sometimes with the same name. I use the example of my mom's name because her name is Maria Perez. And I think in Colombia, maybe we have more than 2,000 women with that name. So we try to work, with the official sources of information to avoid to make a mistake with this part. So, well, the first step is contact by phone to this person and verify the identity of this person. If contact by phone is not possible, then the professional goes to the domicile. Sometimes we got from these external entities the address for the persons. In here, it's really important to say that the information is only provided to the person. Why? Because sometimes nobody else in the family, in the biological family knows about the adoption because the moms gave the consent years ago. Maybe now they have a new family, a new husband, other children. So that's why the information is just shared with the south person. Of course, we offer support to the biological family too, with the aim to establish, the feasibility, the preparation, and the interest of this biological family about a potential reunion, with the adult adoptee. Of course, just when the biological family say, okay, you're authorized to share my information, we will share that contact information with the adoptee because we need to respect too the privacy of these biological families. Sometimes the biological moms are not ready, they don't want to reconnect with the past. So it's really important, this part. Okay. Which are the potential results of the search? Sometimes we found biological relative has deceased, and then we sent a copy of the death certificate. Another option is that the contact data provided by the external bodies doesn't enable the location of the south person, because in Colombia, it's really common that you find the promotion in the cell phone companies and you change your number every single day. And we have not the good practice to change the information in the entities. Okay, another potential outcomes is that south person is not willing to have contact with the adoptee. And the last one is that the south person wishes to have that contact, and then we organize a physical or virtual meeting, it depends, and we offer the support for this meeting. Then, of course, we will do a follow-up by phone or email, or maybe by video call, with the biological family and the adoptee, just in case, they need us in some way. The last service is the biological family searches for adoptee. According with the Colombian legislation, the biological family loses all its rights and duties in relation to a child, and any legal parentage terminates when an adoptability resolution or a consent granted by the biological have been expressed. However, any member of the adoptee's biological family may request to the ICBF two things. The first one is register or update their contact information in our system. So in order to become this information a source of consultation, if the adoptee in the future asks to us to undertake an active search for his or her family, of course, this will help us to do easier, this duty, because sometimes it's really hard to find people. And they can, of course, submit with the request, a letter, maybe pictures, things like that, in order to share them with the adoptee if they, of course, ask to us to start this process for origins family search.
Thanks.
Go ahead.
Thanks, Erica. It's a very clear explanation of how the search for origins works for both ways, for the adoptee and also for the birth family. Can you just briefly mention a few promising practices? We're running out of time, but just a few highlights would be great. Thanks, Erica.
Thank you. Thank you. Okay, I want to share with you just a little things about the importance to prioritize the right to identity. We do some practices in Colombia that maybe could be useful in other countries to, in order to guarantee this right. So as part of the child protection process, if there is not a birth certificate requested by the biological parents, then the family defender must request the child's registration, in order to safeguard all his fundamental rights. Another thing is that once adoption judgment has been issued, the original birth certificate becomes void, but is not removed. Both are saved in the civil registry offices and the notary's offices, with the mention that it was replaced by the post-adoption birth certificate. Both certificates are in the same civil registry, so it's easier to find them. In our guidelines, the adoption guidelines, as part of the process, we include the preparation of the applicant families for both domestic and international adoption, the development of tools to manage information about the child's life story, the adoptive identity, search of origins, preservation of the language and recognition of the cultural traditions of the country, amongst others. And two, in Colombia, of course, we try to match, when we are talking about assign a family to a child, to match child with Colombian families, in order to preserve their origins too, of course. And we all know that the international adoption is subsidiary. So, and of course, in Colombia, we have the search for origins procedure, and it was designed in order to, as I say, guarantee this right to know about their origins for the adoptees. And I just want to mention 4 things that we consider is important for us to work together, Javi, and that maybe could help us to improve.
I think we'll have to. I think we have to. No, I think we have to slow down. Yeah, but I will share your slides with everybody. It's just that we're running, and it's getting later and later for those people in Asia. It's way past midnight for them. But thank you, Erica.
Thank you. Thank you for the
invitation. Very
invitation.
important to have the Colombian Central Adoption Authority with us. They've really, for us, have one of the leading practices in terms of search for origins. It's one of the most advanced systems. They have the legislation, their dedicated resources. So thank you for that, Erica, and also the rest of the team that is here with you today. What we will now turn to is another example, but now from a receiving state. Of course, they were not able to be with us because it's now, I think, let me think, it's about 1 o'clock or 2 o'clock in the morning now for them, but they've prepared us a short video. It's a 10-minute video. It's Tim Crossier from the Australian Central Adoption Authority. He's the branch manager of Children's Policy Branch, who'll present on how the Australian Central Adoption Authority is dealing with this question of post-adoption support. And so thanks, Gisela, for sharing that now.
Hello everyone, my name is Tim Crozier and I'm pleased to have this opportunity to represent the Australian Central Authority for Intercountry Adoption. I'd like to thank Maya and Chip for extending the kind invitation to participate and also to present to you in this important webinar. We're meeting today on many traditional lands around the world, and I'd like to acknowledge the traditional owners and custodians of those lands and pay my respects to elders past, present and emerging, and extend that respect to any First Nations peoples present. Protecting a child's right to their identity in intercountry adoption is a fundamental aspect of Australia's intercountry adoption program. As the Australian Central Authority, which I'll refer to as the ACA, we are responsible for enabling Australia's obligations under the Hague Convention and the United Nations Convention on the Rights of the Child. The roles and responsibilities of the Australian Government and state and territory governments are set out in the Commonwealth State Agreement for the continued operation of Australia's intercountry adoption program. This agreement includes a national action plan, which sets out priority action areas to ensure intercountry adoption practice remains focused on the best interests of the child. Under the Commonwealth State Agreement and the National Action Plan, Australia employs a number of strategies and programs to support adoptees and their families. The intercountry adoption journey can be a complex, sometimes traumatic process that requires additional supports, and in some instances, lifelong supports may be required. The ACA is regularly reviewing and improving our policies and practice, and where necessary, creating new policy and practice to ensure the safety and protection of children. A significant component of work in this space involves collaboration with key partners within Australia and internationally, such as International Social Service, International Social Service Australia, and the Intercountry Adoptee Advocacy Group, Intercountry Adoptee Voices. Our relationship with these partners is critical, and we highly value their expertise and knowledge, which assists us in upholding our commitment to best practice in intercountry adoption. Currently, there are 5 key pieces of work Australia is committed to upholding to support the protection of a child's identity. I'd like to provide you with a brief overview of these and to describe our collaboration with adoptees and adoptive families to ensure our policies include the voices of those with lived experience. These 5 pieces of work are the redesign and implementation of the Intercountry Adoptee and Family Support Service, country program reviews conducted to ensure our programs are compliant with the Hague Convention, monitoring and reporting of illicit practices, adoption disruptions and breakdowns, our collaboration with the Permanent Bureau of The Hague and members of the Hague Working Group on preventing and addressing illicit practices in intercountry adoption, and our tracing and reunification project. I'll just go through each of the action areas one by one. So the first action area, the redesign of the Intercountry Adoptee and Family Support Service, known as the ICAFS. Now, the ICAFS is a nationwide service funded by the Australian Government, which provides free post-adoption support to adoptees, adoptive and prospective adoptive parents, and the families, children and partners of adoptees. It provides counselling and case management to help the community manage the complexities and unique challenges intercountry adoption may pose during a lifetime. In early 2020, the Department held consultations with the Australian intercountry adoption community regarding the redesign of the ICAFS. Listening to and incorporating the views and needs of intercountry adoptees and other people with a lived experience of intercountry adoption was a key element in this process. Consequently, the new service has expanded from the provision of therapeutic services to also include community capacity building, a small grants and bursaries program, and has a greater focus on the adoptee being at the centre of all services provided. When determining the service provider for the ICAFS, the Department consulted with an expert advisory panel consisting of people with lived experience and academics in the field of intercountry adoption. This consultation process supported the Department to choose a provider that is aware of the unique needs of the intercountry adoption community in Australia. In addition, an essential component of the ICAFS is for the provider to establish and maintain a committee of those with lived experience from whom to seek regular guidance on the design and delivery of the program. This group is also greatly influential in the community capacity building activities and the Small Grants and Bursary Program, and ensuring the ICAFS meets the needs of the community. Now, the second action area is called Country Program Reviews. Country Program Reviews are routine elements of our work at the ICA. Per the Commonwealth State Agreement, we review the ongoing compliance of our 13 partner country programs against the Hague Convention every 2 years. Each review considers information about the intercountry adoption frameworks, policies, practices and safeguards of our partner countries. This includes ensuring states of origin preserve as much information as possible about the child's identity and encourages state and territory central authorities to obtain additional information where details provided during matching are insufficient. The reviews also consider in-practice information and identify any issues or concerns raised by the Australian state and territory central authorities resulting from their working relationships with overseas central authorities. Reviews make recommendations on the future of programs, including actions the ACA must take to ensure continuous compliance against the standards of the Hague Convention. This decision is reached through unanimous endorsement by all Australian central authorities after extensive consultation. The third action area is monitoring and reporting of illicit practices and adoption disruptions and breakdowns. Tracking and reporting instances of adoption difficulties, disruptions and breakdowns, as well as confirmed and suspected cases of illicit and illegal practice, enables us to maintain oversight of cases of concern and provide guidance and support. It enables us to consider any risk factors or patterns observed and take action to prevent further incidents. Where adoption suffers difficulty or breakdown, state and territory central authorities and local child welfare authorities work with the child and adoptive parents to offer counselling and support. In the case of illicit or suspected illicit adoption, focus is placed on re-establishing the child's identity as quickly as possible, with the jurisdictional central authority responsible for working with the central authority in the child's country of origin. In this instance, the ACA works with other Australian government departments to secure the child's safety and ensure pathways to citizenship or permanent residency are not jeopardised due to an illicit practice perpetrated upon the child. Now, the fourth action area is preventing and addressing illicit practices working group and toolkit. Australia recognises the inherent risks associated with intercountry adoption, including the risk of a child's loss of identity. We are committed to enhancing our capacity to influence international practices to reduce this risk through collaboration with the Permanent Bureau of The Hague and other contracting states to the Hague Convention. One way Australia achieves this is through membership in the Permanent Bureau of The Hague Working Group on preventing and addressing illicit practices in intercountry adoption. This working group has developed a toolkit to assist contracting states to strengthen their policies and procedures to better protect children from illicit practices in intercountry adoption. Australia consistently strives to not just meet baseline standards set by The Hague and other international bodies, but to establish and meet best practice, as this ultimately will ensure the safety and protection of children. The final action area I would like to talk to you about is Adoption Area 5, Tracing and Reunification Project. Intercountry adoptees have the same right to identity as non-adopted persons. However, adoptees often do not experience the same access to information about their identity. Consultation with the intercountry adoption community indicates many adoptees are interested in finding more information about their birth family, heritage and adoption. Tracing and reunification services can assist adoptees to locate information about themselves and their adoption. The ACA is currently working to initiate a project to assist adoptees access documents and information about themselves, their family history and their adoption. This will involve providing referrals to information held domestically and overseas and facilitating comprehensive and trauma-informed counselling services through the ICAFS to help guide adoptees through the complicated and often emotional process of tracing their origins. So in summary, Australia's model of intercountry adoption is based on a cooperative approach that is squarely focused on the best interests of the child, is fair and transparent, and promotes best practice. It is informed by key learnings from past illicit and illegal practices, consultation with the Australian intercountry adoption community, and collaboration with key stakeholders, both nationally and internationally. In this way, we are better able to manage our policies and procedures and ensure that all decisions are made based on the needs of the child rather than on demand generated by prospective adoptive parents. In turn, we position ourselves for the future of intercountry adoption and maintain concerted efforts to protect the child's right to the preservation of their identity and provide assistance and protection in instances where they have been illegally deprived of this right. Thank you for the opportunity to present at this webinar. As this is a recording and there will be no chance to answer questions, I encourage you to send any questions you may have regarding today's presentation or on the Australian Central Authority to ICAP programs, ICAPROGRAMS @dss.gov.au. Alternatively, please ask Mia and she will be able to pass on our contact details.
Okay, that brings us to our second last presentation, but certainly not the least of our presentations. We have now with us Professor David Smolin, who many of you know has been working in intercountry adoptions for many years. David, I'd really like you to be able to focus on in terms of the future of intercountry adoptions, because of the complexities of providing remedies for victims of illicit practices. Would you be able to answer this first question? Who are the victims of illicit adoption practices, and what remedies and forms of assistance should states ensure are provided? So I'm guessing, I think it's not just a theoretical, we'd like to do it, but what should they really be doing? Thanks, David.
Sure. Well, I'm very glad to be here. I've thought hard about what I could add because you've got great speakers here and they've said so much. I want to really talk from my lived experience, not so much the law professor hat here today, particularly as an adoptive parent of children who were taken improperly from their families. Because we've talked a lot today about origins and the right to identity, and it often has been in circumstances of what I'll call normal adoption. But what I want to posit at the start is that when we tackle remedies for illicit practices, we cannot use the same procedures or the same framework as we use for normal identity searches, origins, okay? So we have, of course, the adoption triad, and we have been somewhat successful in some places in moving from an adoptive parent focus to an adoptee focus. And there's now a focus, as we've just heard, from both Colombia and Australia on providing services for adoptees as they are on their journey of identity. And we all understand, and of course Linnell talked to us about the inherent nature of intercountry adoption, the trauma that goes with it, and the journey that that creates for adoptees. But what I want to tell you after almost 25 years of personal experience trying to deal with the aftermath of an illegal adoption is that the interests and attitudes of the adoption triad members are often in sharp conflict with each other, and that the normalization of an illicit adoption to a normal adoption and this lens of the adoptee journey is not adequate. It's a part of the picture, but it's not all of the picture. In order to do that, what I want everyone to do is to picture, if you have a child or you've raised a child, picture that the child is just gone against your will, okay? Let's say that you sent the child to summer camp and then all of a sudden they're not coming home from summer camp, they're just gone. What would be the timeline you would expect? What would be the reaction you would expect if your little son or daughter just disappeared now, okay? Would you expect that the timeline would be that you would wait until that child grew up? And then if that child had an inkling to search for their origins, then the process would begin? I don't think so. I think you would expect and want remedies sooner while they were still children, okay? So there's a kind of disjunction. In my experience, you know, we have to take account that adoptees are in very different places depending on their age, socialization, as to their adoptee journey, and that many adoptees are not ready until they're adults to really confront some of these issues. And yet within illicit adoption practice, we have in essence a family of origin that is a kidnapped victim. They've lost their child. So the dilemmas and the timeline and who calls what needs to be very different. One of the difficulties, of course, with this design is that we're kind of relying on these origin searches to uncover the illicit practices, but the origin searches, as we've envisioned them, do not begin until the adoptee is an adult, by which time it's too late to remedy much of what's happened. In my personal experience, therefore, one of the difficulties is how do you manage these conflicts? Essentially, what are the different timelines of each of the players? And again, I'm not trying to minimize the importance of this adoptee journey, okay? But it is very different to be a stolen child than to be a normally adopted child, okay? In my experience, of course, in most countries, the programs that Colombia has and that Australia has don't exist. And so for most of us who have been faced with trying to remedy illicit adoption practices, whether it's been adoptive parents, and some adoptive parents have worked very hard to do so, adoptees or birth parents, it's been privatized. They've had to do it on their own. So my own lived experience is augmented by the fact that many people in the birth triad have come to me in the adoption triad and said, basically, what do we do next? And while I appreciate the inspiring notions of these best practices, our usual experience has been that even if we go to central authorities, we go to the intermediaries, we go to the agencies, and we even present them evidence of illicit practices, they normalize the adoption into this, okay, what does the adoptee want? If they're even concerned with that, usually they're not, you know, but if the adoptee is 5 years old, 10 years old, you know, are you going to wait all of these years? I think that we need to have mechanisms in place that treat potential illicit adoption like a kidnapping, rather than treating it like a search for origins. That, I think, is the fundamental point. We need also to be able to build off of what the research has shown us. So I think we know today that if children were adopted from certain countries through certain intermediaries, that there is a very high risk of illicit practice. And yet, in my experience, even with that knowledge, we treat those adoptions as normal until the children grow up. And then they begin their search for origins, by which point it is too late. So we need to connect the dots. We need to have those experts who have been able to determine that certain pathways for illicit adoption were compromised by systemic illegal practices. And I'm talking about the kind of illegal practices that are not just technical, but that basically meant the child was not adoptable and should never have been adopted at all, and certainly should not have been sent overseas. So in that kind of scenario, governments need to be proactive. They can't be waiting on adoptees. They can't be waiting on adoptive parents. They cannot be waiting on the families of origin, because each of these three groups have things that handicap them from coming forward. Adoptees are too young, they're on their journey. Adoptive parents don't know much. They're afraid to, quote, lose their children. And usually families of origin are very disempowered in their own cultures, may have not much literacy, not much access to services, no access to lawyers, no ability to really put themselves forward, because that's why they were targets of exploitative practices to extract children, is because they were vulnerable to start with. So if we wait for one of the three groups in the adoption triad to come forward, it will be too late. So once we see a pattern in the past, there need to be entities that can proactively act and not simply wait and respond, okay? Now, of course, at this point, the groups that are least likely to come forward because they're so disempowered are the families of origin, because there aren't mechanisms. If I heard the Colombian process correctly, and it is our model and one of our best ones, so I'm very glad they were here, if a birth family comes forward in Colombia, they can give their information, but they can't do anything else. They have to wait for the adoptee to come forward, by which time it's really too late. So I appreciate what they've tried to put together, but what Colombia has put together there is a response to a normal origin search that is adoptee focused. It's not a response to illicit practices, which in the context of Colombia, I appreciate, but Colombia, like many other countries, does have a past history. Again, I'll emphasize past, of some significance illicit adoption practices. So relying on the fact that Colombian law, states that the family of origin has no rights to the child because they've signed those rights away, in the context of what we know about so many countries. I'm not trying to pick on Colombia. They've come forward. They're doing great. They're doing better than most of the countries of origin here. In most of them, there is no pathway whatsoever for the adoptees or for the first families. But you can see the difficulties that even when we construct a system for origins, we haven't constructed a system for remedying illicit adoption practices. I think that once we see that when we try to create a system for illicit adoption practices, how difficult it is, we see one of the difficulties with continuing inter-country adoption. We're just starting to create these origins protections, birth record protections, adoptee focused services. They only exist in a few countries, I would guess. But as we do that against our knowledge of systemic adoption practices that have existed for 70 years across the modern history of inter-country adoption, then we have a kind of a mismatch. We're trying to create new systems as though the systems operated correctly. And we can't create new systems for origins as though the system operated correctly for 70 years when we know the system did not operate correctly for 70 years. That's my fundamental message. And I think it's important to include people like myself, all three members of the adoption triad, who have had this privatized experience of self-remedying. I've seen the next generation. Now, I've seen my adoptive daughter have children who are then interested in being connected to India, and then who then again are going to deal with the back and forth. How does each member of their family feel if they have an interest in that? We're connected to the next generation in India as to, okay, it's not just the birth parents in India. We've already seen the death of one. We've seen the next generation, the brother's children. We've seen how these connections work out over time. Many of the speakers pointed out how intergenerational this is. And so there are many of us who have been self-remedying for 10, 15, 20, 25 years, these illicit adoption practices, trying to deal with the disjunction in interests, willingness to confront this, and have lived experience not just about origins, but about remedying illicit practices, okay? We have to recognize with adoptees that we have recruited them into an identity. And the very act of recruiting them into this identity, having an adoptive family, growing up in it, coming to love them. I love Linnell. She is a great spokesperson for adoptees, but in my experience, most adoptees are not where Linnell is in their journey. They're not as self-conscious. They haven't traveled as far. They haven't confronted the problems to as great of a degree. They're a lot more naive, and understandably, they've been recruited into this identity. This is their lived experience. They grew up in these families. And they're going to have a very difficult time as they confront illicit adoption practices, and the idea not only that they have the same complex identity as any other adoptee, but maybe the very formation of the identity they've been recruited into is based on crimes and lies. And I don't think we've talked sufficiently about, not just the normal adoptee journey, but the adoptee journey in the context of crimes and lies. Let alone the birth parent journey with crimes and lies. So the central message is we need to have systems separately for illicit adoption practices. We cannot rely on the normal origin systems. I think that's clear as a concept, and that we need to enlist those with lived experiences of privately trying to remedy that intergenerationally. And then and I guess my main message to the countries considering whether or not to continue inter-country adoption is live that for a while before you decide whether to continue. You have to experience the collision between a crying mother of origin and adoptee who may not be ready to fully engage that, or an adoptee who's ready to fully engage, and a mother who's been so traumatized and has been so shown that she must put away her status as a mother that she's not ready to confront herself as a mother of loss. And then adoptive parents who've been recruited and, as Nigel will say, have paid to care, all of a sudden realizing that they've paid money into a system where the money has been used to facilitate an illegal adoption that should never have occurred. And the different places that each of these people are at processing that trauma. I don't know that these systems that we've constructed are expert in them yet.
Thanks, David. I think, I'm always a fan of what you have to say, and it is something we seriously do need to consider in terms of setting up our systems to deal with illicit practices. Thank you for that. I'm now going to turn to Nigel. I can see that we've not completely run out of time. We're a little bit over time, but I think everybody is pleased to have Nigel Cantwell with us. We all know him. Often represents UNICEF, independent child protection consultant, working many, many decades on these issues. If you bear with us, he will finish a little bit over time, not because of his fault, but it will be the grand finale. I've given him the green card, like an open card like Linnell, like all of you. But Nigel, tell us what you think the future of intercountry adoption should be like.
Okay, for your grand finale, I'll start by stating the obvious, which is, I think that if we were looking to launch intercountry adoption as a child protection measure today, the last thing we would do is to choose the system that we have currently and which we inherited essentially from the 1950s as being the most appropriate means of achieving our goal. And I say if we were looking at how best to organize intercountry adoption, because in the light of experience and as others have pointed out today, in particular perhaps Linnell, in the light of experience to date, we might actually not want to envisage moving children halfway around the world in an attempt to protect them. We would probably want to establish a framework for ensuring intrafamilial and other special case placements abroad, but we wouldn't be constructing a child protection system that involved cross-border movement. Before I go any further, I just want to point out one thing that we may forget or not even know, and that is that during the drafting of the Convention on the Rights of the Child, the very first draft presented by Poland actually had in it a provision which said that the governments or states should have the obligation to facilitate adoption. And that was right at the start of the 80s. And through the 80s, as we know, we received more and more information, documented evidence as to problems with adoption, and in particular, but not only, in fact, intercountry adoption. So by the end of the 80s, that whole idea of facilitating intercountry adoption had gone out the window, and we ended up with the kind of provision that we have now in Article 21 of the CRC, which is very much protective of the rights of children as opposed to facilitating adoption at all costs. And of course, that is reflected in the Hague Convention, as Laura pointed out, in the title of the Hague Convention, which talks about protection of children in this context. So this really sets the scene in a way for me in terms of the way that we are approaching, or we should be approaching adoption. Not facilitating, not trying to continue it at an intercountry level, but really looking at the protection side of the the issue. So in fact, what we have is a current framework that is a kind of relic of the pre-rights era, when inter-country adoption was seen as a humanitarian act. And at that time, of course, the role of the private sector was, rightly or wrongly, an inescapable factor in carrying out inter-country adoptions. And since that time, developments in legislation at both national and international levels have basically reaffirmed that key role of the private sector in inter-country adoptions, even though we now consider inter-country adoption as a child protection measure and not a humanitarian response. And one of the negative consequences of this is that, in complete contrast to other child protection measures, it's the potential carers, as David rightly said I was going to say, it is the potential carers, the prospective adopters, who pay for the right to provide care through inter-country adoption. And this is not only not logical, but it is not defensible from a children's rights standpoint. Now, of course, the Hague Convention is grounded in the Convention on the Rights of the Child, but unfortunately, the Hague Convention, like the CRC, reflects the view of the 80s and 90s that the rights in question, including those very relevant to identity protection, which are numerous, as was pointed out this morning, could be adequately ensured, that you could adequately ensure these rights through an international consensus, in particular on necessary procedures, stricter regulation, and enhanced safeguards. In other words, essentially international cooperation. So the Hague Convention foresees an obligatory and much amplified role for the state, but nonetheless consecrates the key mediation activities of non-state actors. In other words, what the Hague Convention is saying is essentially pay to care is fine, but within limits, and we're setting those limits which will be enforced. But as we've seen, the emphasis on regulations and their enforcement is not effective in preventing adoptions that, among other things, unduly deprive children of their identity. As the Dutch report has at last pinpointed in an official document, however ethical private agencies may be, and however legal and transparent the financial transactions that they undertake, they are the key players in a pay-to-care system that severely jeopardizes the likelihood of inter-country adoptions being carried out in compliance with the human rights and best interests of each child concerned. Like it or not, they are a major component of the pressure exerted by receiving countries on those other countries from where adoptable children may be made available. I would say that arguably the tenor of the Convention on the Rights of the Child does not support the idea that inter-country adoption be carried out on the basis of preconceived programs with agencies, and even less as a result of quota arrangements and requiring humanitarian and other aid, as well as other preconditions for adopting from the country in question. The emphasis of the CRC, as we well know, is on the best interests of each child for whom inter-country adoption is envisaged. And whether or not we think that best interests of the child can truly be objectively determined, particularly on a long-term basis, that approach of the CRC does not tally with putting in place programs, establishing quotas for numbers of children to be adopted, and setting other conditions that are totally irrelevant to ensuring the best interests and rights of the children concerned. So in sum, we've undertaken what I would say is a necessary, although unsurprising, review of past and present problems and mistakes, And that shows what is needed above all is a framework that enshrines the child-centered nature of intercountry adoption as an exceptional protection measure, as Linnell would say, a last resort. And first and foremost, though by no means exclusively, that framework must eliminate the indefensible, adult-focused, demand-based, pay-to-care approach to the practice of intercountry adoption. Voila.
Thanks, Nigel. That was very, very clear. Did you want to add some other key features of a human rights compliant framework, or that is the key message you want to finish on in terms of
I can finish there, but I would like to say that in the kind of framework that one might envisage, which would eliminate the role of agencies because they are the basis of the pay-to-care system, we shouldn't neglect either what has also been pointed out by others, that the idea that intercountry adoption has to cut all ties between the child and the biological family is also out of the window now. We cannot allow the kind of adoption which completely eliminates the possibility of maintaining some kind of relationship with the birth family. Obviously, a source of immeasurable problems. And if the agencies feel unwarrantedly targeted by what I've said, I do think they could have a role in particular in the post-adoption phase. But that role should then be paid for by the central authority or by the state, let's say, and not something that the adopters have to take on as part of the fees paid. So my basic message would be then that they should be removed from any mediation role, and that would cause the incentive to procure children for adoption abroad to largely disappear.
Thank you, Nigel. Like I told everybody, like I promised you, that was the grand finale for this webinar. We've had almost 4 hours of really, for me, excellent high quality presentations, really showing us the importance of the right to identity. I'm not going to do a big conclusion because we're already 6 minutes late and I'm now supposed to be Swiss and living in Switzerland. But really, I think the biggest takeaway is that every adoptee has the right to know their origins. And I think that if we can't ensure that, then we need to not undertake any intercountry adoptions. Okay, thank you, everybody. Like I said, what we will do is we will put the recording on our website. It's not going to happen straight away, but hopefully in February. We will put presentations as well. Please do write to us if there is a particular presentation that you would be interested in French or Spanish, and we can see if we have the resources to translate that for you. Otherwise, they will be available in English. For the questions that have been sent, I've seen that there are about 10-15 questions that have been sent. We will do our best to respond to those that have been relevant. It's now Friday afternoon for us, so we won't be doing that today, but be assured that we will respond to you based on our resources. And please, I think the big message for us is let's continue to work to ensure that every child right to identity and all their other rights in the Convention on the Rights of the Child are upheld. It's really important because we don't want these generations and generations of heartache that we have created. Thank you again. Have a good weekend, everybody. Sleep well, Linnell and others that are in the Asia Pacific. Have a good weekend to others. And thank you again to the to the speakers that have really prepared well and really shared with us your expertise. Thanks again. Goodbye.